morning, District F. All right. Hey, that's right. Thank you so much for leaving your warm beds and warm homes to join us this morning. And I was just sharing that in order to get people to get out of their house on Saturdays, we have to make it worth it. So I want to appreciate our partners and our sponsors today. For those that do not know, I am your council member, Tiffany D. Thomas. I have the honor and pleasure of representing you at City Hall, representing District F on the west side, the best side, that's right, of Houston, and really appreciate that. The neighborhoods that I represent, and I believe most, if not all, are represented today. We have Alief, West Chase, Tanglewild, Westmont, Carver Crest, now Blossom Heights, and Briar Meadow. And so, those are the communities that I represent, and I believe everyone is in the house, and we'll continue to welcome folks today. So one of the reasons why this is so important, before I introduce our partners and our speakers for the day, is because when I went through the 16,000 311 calls we received in 2022, there was a spike in building code violations. And I was paying attention to the trend, and when we started digging deeper, I realized this was related to deed restrictions. And many neighborhoods are having serious complications in their communities related to building violations. In Tanglewild, there was an investor that took a single family home and made 10 bedrooms, an apartment building in a single family. You have in Carver Crest, there was someone who was building without permits. You have in Ashton, a homeowner that has just refused to take the appropriate actions to maintain their property, and in consultation with a colleague at City Hall, our vice mayor said, you need to reach out to Rice & Rice Law Firm. They have hosted a similar workshop in District K, which has been successful, and I'm so honored that they were willing to partner with us this morning. So I want to introduce them as well. Before we move on with our program, a couple of some housekeeping. We do have information on your table that is for you. I want to bring your attention to the Register Your Civic Club and your HOA. We have Veronica Hernandez. She's a senior liaison out of the Mayor's Office of Assistance. Veronica, raise your hand. And so Veronica, in District F, we have 14 abatement cases happening in the district. We are working with her and the Department of Neighborhoods regarding those cases. If you have particular questions about that process or those properties, you can speak to her directly. She has updated information, and she can share with you the status of the inspection, where we are in that process. As we know, in Texas with private property rights, it takes a lot for the city to come in and do something, so she can walk through that. Also, we want to make sure that you are registered, so we have your information at the city, and we know where you're at, so we can stay in communications with you. None of this would have been possible without the law firm of Rice & Rice, and you'll hear from them today. Extraordinary wisdom, and we're going to have a great conversation. And I also want to thank the caterers today that are filling your belly. Is the food good, or is the food good? I know some of y'all probably ate already, you know, because y'all didn't think y'all thought we were gonna nickel and dime y'all, but we didn't nickel and dime y'all. So I want to thank you, and Colby's Culinary Creations, and they're located right there in Missouri City, not too far from us. So if you're, having an event or an HOA or National Night Out, definitely consider them as a partner for your event. I also would like to announce CenterPoint Energy, and this is not a regular. Nora Luna, the program manager, not only is she with CenterPoint, but she's my neighbor. She's a resident of District F, and my HOA president is here, Kelly Fash, good to see you. But she's with CenterPoint Energy. Please visit her table. She's the lead on the CenterPoint's Energy Residential Standard Offer Program, and this program offers incentives of a wide range for contractors, service companies, community agencies, and other organizations for the installation of energy efficient projects within the CenterPoint footprint. If that is of interest to you, please connect with her, and I'm sure if there's any other questions around CenterPoint, her and her colleagues can facilitate that as well. So there's been a few changes in the District F office, and good changes. And many of the colleagues that you worked with in the past have gone on to advance their careers, and I'm very proud of that. But I would like to introduce my new District F team, the Remix. That's what I'm gonna call them, the Remix. If y'all can come to the front briefly. Isaac Iguea, Chief of Staff. Isaac lives in District F, product of the Alief ISD school system. And when we were interviewing, and I said, Isaac, are you telling these people you're interviewing? Because I don't want to get in trouble with the superintendent. He was like, yeah. So the superintendent sent me a text message and was like, really? And so he keeps bringing it up. So he was like, you took one of my stars. And so the good thing is that we're still all in relationship. Isaac starts on Monday. You don't bombard him too much today, but Isaac starts on Monday. Long history and rich history in the community. Stephanie Nicole Leota, Director of Constituent Services. Stephanie comes to us from Representative Lizzie Fletcher's office. She was a Wounded Warrior Fellow, served 6 years in the United States Army. We thank her for her service. And she also, let's go ahead and clap for that. That's so important. And many of you are familiar with Stephanie because she was Representative Fletcher's outreach manager and would attend some of the same community and civic club meetings. So she's familiar with our footprint and our reach. And so she's transitioning to the city office, and she starts on May 1. So walk her slow. So, don't bombard her as well. But I'm excited about her background, her understanding of our district, and her understanding of case management, and she'll really be able to elevate our work. And then many of you have probably corresponded with Ken Ulmer. He's the Director of Communications. Putting together those newsletters, press statements, all of those things to make sure that you are informed. That comes out of Ken's house. And then Ms. Kathy Reese is my new administrative assistant. And she's not here with us today, so she keeps me together. So we're gonna give her some big love because she'll keep me organized. So I wanna thank you so much. And they'll be at the back table if you have any other questions for them. So before we get started, I want to make sure we reserve most of the time for conversation, and hopefully you have copies of your deed restrictions and your questions. We will have Q&A. We have a mic in the back, and Stephanie will assist in managing that, and we'll allow the speakers to lead that. Uniquely in District F, just some fun facts about our neighborhoods. We have 3 neighborhoods that do not have HOAs. Tanglewild, Westmont, and Carvercrest. So every neighborhood is uniquely different. They present their own challenges, and some of them love the fact that they don't have HOAs. Right? I mean, some of the people in the room are probably like, yay, no HOAs. So feel free to ask those hard and tough questions. I want to make sure that I am offering programming to you that is meaningful, that impacts the quality of life in our neighborhoods, and hopefully to help you, it's an incentive and a motivator to keep you in your neighborhood because you feel protected. And then I'll do whatever we need to do on the city's end to make sure that that's happening. I think those are all of my remarks. Did I not? Oh, I also want to acknowledge Frostbank. I'm sorry. So after we have this conversation, our partners with Frostbank will continue the conversation with talking about the deed upon death. That is a tool that the state legislature approved several legislatures ago, where separate of a will or estate, you can designate who you want to assume your property, your asset. And I will tell you that my family has already participated in that for my father's home. So that is definitely a tool that you want to take advantage of. And then we'll also hear a presentation around protecting your home from fraudulent contractors. We know in Houston, it's not a matter of if, but when a disaster happens. We all remember Winter Storm Uri, and I remember I had 3 busted pipes, and my neighbor, there was a contractor who was trolling, and he spent maybe $300 on something that didn't cost that much, and it wasn't protected, right? So we want to make sure that you have everything you need, so you're not taking advantage of. So please find the time to stay through the program to get those resources and share. HTV is here. They'll be recording. So let's behave. We're going to be recorded. And this will also be shared and added on the website and in the newsletter as a resource. So you can share this with your neighborhood as an ongoing tool. This is not the one time. So we want to make sure that we capture this information for you. With that, that concludes my remarks. I'll be out here on the floor, but we're going to go ahead and get started. Are we ready? Wonderful. Thank you much.
Yes, ma'am. All right. Thank y'all so much. Let me introduce myself. I'm Susie Rice, and this is Garrett Rice, and I've been representing HOAs now for about 38 years. Garrett's not even 38 years old, so he's not quite there yet, but he's getting there. And so I have helped the legislature with writing 204 of the Property Code and sections of 209 of the Property Code. So we have a lot of experience with HOAs. We represent HOAs all over the state of Texas. So we have seen every problem that you can think of. What we're going to do today is something different. Instead of us stand up here and go through the boring statutes and you go, oh my goodness, I heard stuff, but it was more legal jargon. We are going to have y'all tell us what your problems are. We're going to discuss different issues, what the legislature is even considering right now, which I'll go over that briefly. The legislature is right now thinking about allowing people to have up to 6 rabbits and 6 chickens, no roosters, and they can have them in their backyard. And they're even considering letting people have, I guess, massive gardens in their backyard, which I don't have a problem with a garden, but then being able to sell that up to $50,000. So you could make up to $50,000 on selling your fruit and vegetables, whatever else you raise. They also want to open it up to where homeowners who live in a neighborhood could essentially use the common areas to have meetings themselves. And we really couldn't stop it, so they could get out there and talk about anything that doesn't jeopardize the health and safety of the neighborhood. They also are talking about making it to where you have to send 3 separate notices before you can file a lien for somebody who owes past due assessments. And they want to have HOAs audited every year. And an audit is expensive. It's very expensive. So they want to have a formal audit done. And that can run you $5,000 to $10,000 depending on how big your HOA is and how long it's been since you had an audit. So those are some of the issues that they are considering at this point in time. And we've been dealing with the legislature. We work with other organizations so we'll see what comes out of it. But if you want to, you can actually go contact your representative and find out from them what's going on with the HOA legislation. They'll be able to tell you if it's in committee, if it's moved out, or what stage it's actually in. So that's what we're looking at with regard to them. Every year, every other year that they meet, it's always something different. So what we need to do today is, if y'all want to, raise your hands, go up to the microphone, and let's start talking about some of your problems. And I know, yes, and the microphone is right there with Councilmember Thomas. And she mentioned 3 of the associations or 3 neighborhoods that have restrictions that do not have HOAs. Section 204 of the Property Code does deal with that, and it can be used, but there are certain qualifications in that particular section. It's 204.006 of the Texas Property Code, and what it essentially says is if you have more than 60% is what is needed to amend your restrictions, then we can form a petition committee, and 60% of the owners in the neighborhood can vote to establish a homeowner association. And we find that in Houston is very prominent in different areas because Houston is an old city that started years ago creating neighborhoods that were restricted, and we have some that were created 1940s, 1950s, 1960s, so they didn't foresee and couldn't foresee the problems that we're having nowadays, and they may have restricted it, but they didn't create an HOA in it. So what we did is with 204, the property code, we made a way for the HOAs to do it. And that way you don't run into problems of having to change all the other aspects of it. You can just be creating a homeowner association to manage those restrictions. And I know to some people, HOAs are like, oh my, who wants one of those? We read about them in the papers, on the internet, we look at them on the news, they're horrible. But the good part about it is, if you run into a problem with your neighbor violating those restrictions, do you as an individual want to personally have to sue your neighbor? What do you think that's going to be when you live next door to your neighbor? That's what the HOA is there for. The HOA is there to help enforce the restrictions, and you can go to them and say, we need you to do something about our neighbor. They've painted their house bright pink, or it now looks like a zebra. We got to get something done. The HOA handles it. Therefore, it doesn't put you in a personal dispute with your neighbor. And nowadays, we all know how dangerous that can be if we're in a dispute with our neighbors. So that's why HOAs are beneficial. And what's also beneficial is the fact of mandatory assessments. You need to have mandatory assessments because in order to enforce those restrictions, you're going to have to hire an attorney to do it. And unfortunately, it doesn't come cheap. It's not cheap at all. So keep that in mind. There are ways to do it for the three neighborhoods that are here that don't have an HOA. If you need help with that, then call us, contact us. We'll tell you what to do. The fortunate thing in Harris County is 204, the property code, doesn't apply all across the state of Texas. It basically applies to Harris County, Montgomery County, Galveston County, and Brazoria County. So y'all are fortunate because it's a very good section of the property code. It even allows you to, if people write you hot checks, then you can basically charge for fees for insufficient checks. It provides a way for you to charge for services that you provide to homeowners if it's not already provided in your governing documents. So it's a very beneficial statute for y'all to use. And if you need to ask questions today about any problems you're having and whether it would be applicable to, whether 204 or 209, the property code would be applicable, we'll be able to tell you. So who wants to start off with the first question?
Please come to the mic because we need it for HTV. So we're going to ask for questions. If you can just line up to the mic and we'll receive your questions. Thank you much.
We have a couple of problems. I'm in Imperial Point, and one of the ones that's happening right now that looks like a neighbor has moved in a little mini house behind their garage. They had their garage into a living space, multifamily living space, and now they've moved this little mini house in, and then it looks like they're going to use that as a worship place. And so my question is, can they make? First of all, I know if they go in and they make that a living space, that changes to a multi-dwelling place. But can they make it a religious place, like to come and worship? That's one, and I know you're going to answer all of them. Do you want everything? I'm going to give you two more.
Okay, let's deal with those two, and then we'll go to the next two. What you need, and y'all are deed restricted community?
We are, and that's a problem too, which was another question. So our homeowners, they'll give them a notice that they're in violation, give them another notice, and then they do not follow up because they don't want to pay the lawyer. So that's a question. What can we do with them?
Well, first of all, if they're not doing their job, then you and other individuals out there, they're elected. They usually have elections every year, or they should be, because usually the board members are staggered with regard to the terms they serve. Y'all need to get involved and do like you do with any other politician, and I'm just going to put them in that category since they're running for your board. Run for the board. or get people on the board who will enforce the restrictions, because the problem you run into is you have a 4-year statute of limitations, meaning the day that lady started holding religious ceremonies there, or put that house or that little house in, the day that she closed in that garage, your 4-year statute of limitations starts running. The only thing that stops that 4-year statute of limitations is filing a lawsuit. If you do not do something within 4 years, then the courts look on it as it wasn't a big deal to you. You didn't care that much about it, so they're going to let it stand. Then you start running into the problem. Other people see that, and if you start getting a lot of that happening in your neighborhood, then you run into what we call waiver. And you will actually waive that restriction and not be able to enforce it because you've allowed too many people to violate it. So the bottom line is, get people on the board who will help preserve the value of your homes. And that's what HOAs do when they enforce restrictions. They're not helping you out at all. Your restrictions are basically worthless if they're taking the position of, we're just sending a letter. Okay, that does, if people are, and people know that. I have seen neighborhoods like yours where people just are like, well, you don't do anything anyway. Once you start doing something, word travels, and people will start paying attention to the letter. And the thing is we've also found that once they send it to our office, we send a demand letter, it's amazing. People will start cooperating. So there are ways to get them doing it even without having to file a lawsuit. You can get an attorney involved. We send demand letters, and then if we don't hear from them, we will actually send them a copy of the lawsuit we're going to file. That usually gets people's attention because nobody likes to be sued. So that's what I would do there. And then you look at your restrictions with regard to the violations. You want to be able to show the court, this lady is violating a particular section of our restrictions. Because we can't just say, well, we don't like it. The judges want to be able to see, what are they violating? Show me the sections. And so that's very important to look at your restrictions from that point.
Next one is, it's on our side of Imperial Point, 3 entrances into the main part of our subdivision on that side, which backs up to Bel Air West. 3 entrances, there's commercial businesses that are running, like the street is like their salvage yard. And then recently the one on the corner of Boone and Carvel, they have cars that have been parked outside of their business fence in the grassy area, not on the street. Tires are 4 or 5 inches down. It's a nuisance. We have to drive by it. A lot of times they're on Fameway. There's so many junk cars not running and whatever, but it's in the entrance of our subdivision, which, we couldn't park on a city street like that, but they have these junk cars that they're using, the warehouses, they're using the street for part of their storage. And, there's bumpers, there's cars that are damaged, that can't drive. So we're wondering, we've called, and the city says they can't do anything about it. So where do we go with that? How does that impact our residents?
Well, I had a lawsuit years ago, and we had an individual do the same thing. They actually put at the entrance of a subdivision, which was commercial property, they put in, started selling old washer and dryers, old refrigerators, and had those, when the cars have been smashed down by those machines, they had a bunch of those. And so we fought it on the basis of, in Texas, we follow English common law but now we've adopted statutes that apply in certain areas. However, we still follow English common law with regard to common law nuisance. And a lot of your restrictions, like your restrictions may talk about nuisance, but that's with regard to in your neighborhood. You can actually use, and I used it in that case, I said because it jeopardizes the health and safety of the people around there in that neighborhood, we sued them for common law nuisance, and we won. We got it shut down based on that. And so there's a way to do it. Unfortunately, it's going to cost money. And we also have a current case where it's similar to that. At the entrance of a subdivision, a guy works on cars, and there's beat up cars everywhere, and he parks along the street into the subdivision. It's the same situation. You can use common law nuisance to go after those type of people. You'd want your HOA to do it because unfortunately it'd be too expensive for an individual. If they're going to fight, which most likely they will, then you're going to spend money on attorneys. But you can recover those attorneys' fees. Because what we do is we sue them for common law nuisance and we claim a declaratory judgment, and we basically we ask the court, would you find that what they're doing here is a common law nuisance? Under the Declaratory Judgment Act, you can ask for attorney's fees. So there's ways to get your money back, but in the meantime, while you're waiting for that, you're going to spend money.
Thank you.
You're welcome.
Good morning.
Good morning.
Manuel Cortez. Wanting to know if there's a way we can stop renters from renting in an association. We already have 30% of renters in a property. So is there something like the law that goes townhouses and condominiums kind of have a law to stop that?
It's very, very difficult to do something like that. I mean, the legislature has even pulled back on what we have the right to know as HOAs with regard to tenants. The legislature has basically said what you, HOA, have the right to know is their email address, their contact information, and how long their lease is going for. What you can do, and this was mainly HOAs have come up with this, the attorneys have, and this was to stop not long-term renters, but like Airbnb renters. If you want to rent for a weekend or you want to rent for a week or two or something like that, we need to amend the restrictions because the Texas Supreme Court in Tar versus Timberwood, which now has been about 2.5 years, they basically said if you want to control any type of renters on how long they're going to rent, it needs to be in your declarations and stated specifically. So you need to state, if you're going to rent, you can only, the lease has to be 6 months or longer, or a year or longer, something like that. That's really more to control the Airbnb market. With regard to stopping renters completely, I haven't seen any court opinions on it yet because nobody's really gotten that far. I have some HOAs that have said we're going to amend our restrictions and put it in there that you can only have 30% of our homes leased out. That's going to be challenged, and it's going to be a fight. And I can tell you right now that will eventually go up to the Texas Supreme Court, which is going to be a very expensive battle.
May I insert right here quickly just about the Airbnb to that point? So in the city of Houston, we do not have a short-term rental ordinance. My colleague, Councilmember Alcorn, she chairs Regulatory Neighborhood Affairs Committee, and we are at this point collecting information from district members about the number of complaints we receive from Airbnb. Corporate Airbnb had a meeting with owners that have these Airbnbs for the Final Four, right? The party houses. So right now what we're trying to do is collect that information. We've talked about it at council. We hope to route something up through committee and present the administration and city legal with a possible ordinance, but we will need documentation from you if you are aware of those party homes or long-term rentals, because we don't have an ordinance on the books. And we know how disruptive they can be to certain neighborhoods. Most of the time, most of those owners, it's a rental property, they manage it well. However, when you look at Houston as a destination city, we are inundated when you're looking at loud music, quality of life, and especially if we don't have HOAs that are able to enforce. So that is what's happening right now. So if you have that issue, if you could leave your neighborhood at the back table, I want to make sure we capture that data so we can include it with that process. Thank you.
Have any other questions, Manny?
No, thank you.
Okay. Yes, ma'am.
My name is Barbara Kelly, and I'm a longtime homeowner in Tanglewild. I define Tanglewild as one of the original mid-century neighborhoods in the city of Houston. It's at Westheimer, Gessner, down to Westerland. Probably the first home I've tracked back was built in '54, so it's developed a little. It was not developed with a mandatory HOA. We do not even have a voluntary civic club, which was in the documents. Go into that later. I have two questions. One is very easy and very quick, and the second one might be a little more involved. Which would you prefer first?
You choose, either one.
Okay, let's go with the quickie, easy one. Tanglewild consists of 8 different sections. Each section has their own set of deed restrictions, all quite similar, but there are little nuances that are different. Some of the owners claim that their deed restrictions have expired. Where can we go to find out the status of the deed restrictions? There are 4 of us who are active in the community, and that's it. And I have all the documents with me.
Look, when you thumb through the documents, usually it's at the end, and it will talk about, it may be titled amendment, how to amend the documents or something like that, but look in the end, look toward the back of the document, and it will talk about this document will go for 25 years and will, and do you have anything like that in there?
I haven't noticed them, and I've read them very carefully. I will go back and look.
Okay, if it does, then your restrictions are still in effect, because it has to be stated in the restrictions specifically that they expire on, and they'll usually give a certain date that they expire. And then most restrictions will say, you know, the restrictions go for 25 years, and then on this date they will resume every 10 years, blah 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 blah, and they'll go like that. But if yours don't say that they don't expire, then they're still in effect.
Is there a department in the city of Houston where we can go and get that confirmed? Not that I doubt you. It's like to...
It would be, I would say the legal department. I don't know if they have time to address this, because most of those attorneys there, if they're working in the deed restriction section, they're dealing with enforcing restrictions. So what you can do is, if you email me, I can look through them real quickly and tell you that's still in effect, that's not. So you can do something like that, and I can confirm that for you.
Okay. My second question is more worrisome. The neighborhood consists of what, over 600 homes, and as of late, we've been infiltrated with what you and I might refer to as a boarding house. I believe the city of Houston defines it as a lodging facility. I am very disappointed in the lack of response from the city of Houston about these. The one that I reported on August 8th, this morning I drove by, there were 13 cars in the driveway, ditto yesterday. The only official response that I have gotten from the city of Houston was through Councilmember Thomas's previous director of constituent services from the city, telling me I could get my own attorney to pursue the issue. This was reported on August the 8th. The city sent out a representative, an inspector, something like that on August the 9th, had a conversation with the young woman, doesn't own the house, it's rented out, and she confirmed that all these people live in there, they go and collect rent, they're students. I'm 69 years old. This is my single largest investment. And I see 2 things, that it's getting driven into the ground, and we're losing what is, I consider, an original mid-century single-family neighborhood in Houston. Where do we go?
And so they're basically just renting out rooms.
Oh,
Is
yes.
that right?
Just
It's a boarding house. So
Boarding
yeah,
house.
so in the district we have 24 approved applications. And so what's happening is that you have home health operators that take a single family home and they put 4 people to a room, and that's what they do. However, that's what's on paper, but what we're experiencing neighborhoods, that's not accurate. There are many of the individuals can point to a boarding house that's happening. So what's happening in the legislature right now is the state is actually proposing, and I can't recall the bill, but a form letter was in the newsletter. The state is actually proposing to limit the city's ability to even respond to boarding houses right now. So they want that to be at the state level, noise, boarding homes, and other issues that we deal with on a daily basis. So your frustration now with our limits, it's going to increase because that bill will more than likely pass. So I did reach out to a couple state representatives to invite them so they can share with you what's happening in the House. Hopefully we'll get a formal response, but I will send out that form letter because it's really important for you to engage with your state reps in the legislature, because those very issues ties our hands at the city level. We're limited, especially with private property. However, we're the closest to the ground. And so I have raised the same issue to the Regulatory Neighborhood Affairs in order for us to audit the current amount of boarding homes, because what has happened is we've had fires, people have passed away with death, they didn't have smoke detectors, some seniors were missing, because they were in these homes and they weren't necessarily documented. Their family members didn't know. It's a public health issue. It's a public safety issue. It's a quality of life issue. We're well aware of that. But if you are noticing similar issues in your neighborhoods, we need that information. But I want to encourage you to reach out to your state representative and your state senator that they must make sure that Houston can retain local control to address very local issues in our subdivision. But that's happening right now. They're trying to limit our ability to respond to boarding homes and noise.
Yeah, and one of the problems you have is, in order to address something like that, it's going to, I don't know if y'all, it sounds like y'all don't have mandatory assessments and you don't have
We don't have an HOA. We don't even have, our civic club disbanded about 3 years ago. We were uninsurable due to previous lawsuits. Nobody wanted to, I wouldn't do it without being insured. So our money is now all gone because of the way, when you dissolve that, the state requires the monies to go
Right.
elsewhere.
Well, the unfortunate thing is, in order to fight it, it may be you and other owners get together, pool your money together, and be able to hire an attorney and fight it that way. That's the unfortunate thing. And most individuals know that. They look at, okay, what is this neighborhood? Do they have an HOA? If they have restrictions, do they have assessments? So they know that it would take individual property owners money to be able to fight it, and that is so expensive, so expensive. So they will go to those type of neighborhoods, and that's so unfortunate. But like Council Member Thomas says, contact your members of the legislature and tell them they need to leave this in the hands of the city, because the city knows what's going on. People in Austin don't know everything that's going on in Houston. The problems in Houston are different from Austin and everything else, because, you know, you were talking about, that lady said she rents out to students. Well, see, Austin addressed that problem. The city of Austin did, and they passed a city ordinance that dealt with renting places out to students, because, you know, you have UT there, very large school, and people were buying homes and they were renting rooms out, you know, like 2 students to a room. But Austin passed a city ordinance, and you know, the council members here in Houston can look at that ordinance. If the legislature leaves them alone, look at that ordinance and pass something like that for Houston, because it's very successful in Austin. And that was to protect neighborhoods like yours, where people were running into the problems that you have when you have rented to a bunch of kids.
Okay, thank you very much.
You're welcome. Yes, ma'am.
Hi.
Hi.
I'm an outsider. I'm from Missouri City, Texas, Fort Bend County.
Well, I'm glad you're here.
Sorry. Question that I have, questions, is if you have an old deed restrictions, ours is like over 40 years old. I'm on the board, I'm a member, and I read it for everything. That thing needs to be rewritten.
Yes, ma'am.
Seriously. So, and I think our president asked, how do we write that document? Because it talks about making sure you accommodate a parking space in your driveway for your housekeeper. We don't have housekeepers anymore. That's the number one thing they said. Make sure you have you're given 4 parking spaces in your driveway, and one of them must be for your housekeeper. We don't have those anymore.
Yes.
So, and I think we've asked you to do that. What else do we have to do to get that whole document? Because from what I read, the whole document needs to be rewritten.
Well, basically, the procedure you can go through is we'll first look at your restrictions and see what's needed, what percentage is needed to amend them. And then we will talk to the board and find out, what do y'all want? If y'all want it totally brought up to date to where it fits 2023 and what we can foresee for the future, we can do that. And we can rewrite everything. I mean, essentially what you do is you can do, let's say you haven't ever amended it. This would be your first amendment to your restrictions, and that amendment will refer to those old restrictions and say, here's where they're filed of record, and this document is taking the place of those old restrictions. And we cover everything. We bring it up to date with 209 of the property code, 204 of the property code, and we also cover problems that we see like Airbnbs. Who would have known about Airbnbs 10 years ago? And boarding houses and all the problems we're seeing now. We can bring it up to speed to where y'all would then be protected. But the most important thing is, once it's written, I recommend that y'all hold meetings and let people understand why you're doing this. Because if you just throw it out there, email it to them or send it to them in the mail, they're going to say no because they don't understand what is this for. And I can tell you from prior experience with other HOAs, people will then go around and say they're just trying to take your home. They're finding ways to take your home. So meet with the people, talk to the people, tell them, here's what we're doing, and here's what this means, and here's why we're doing this. We want to keep our neighborhoods safe. We want to keep the property values going up. We want to protect from these kind of problems that we see around the state of Texas. Do that, and your chances of getting it passed are a lot higher. So meet with them, educate them, let them know, get them involved, and then once you send it out, people can fill out a simple ballot. Check yes, I agree with the amendment, or no, I don't. And once you get, let's say you need 60% to approve yours. Once you get a little over 60% yes votes, it's done. We take those ballots, we take the amendment, we file it in the property records, and you've got you a new set of restrictions.
Now, I think you mentioned, I'm taking notes, the 204 property code, I think you said you named the counties.
Yes, and you're in Fort Bend?
I'm in Fort Bend.
No, ma'am. Unfortunately, I wish it applied in Fort Bend because I have a lot of associations in Fort Bend, but it doesn't. We have tried to get the legislature to expand it into other counties. What we did is that was passed in 1995. And once it was passed, then everybody was like, we hate HOAs. Get rid of them. They're being mean to us. So we went back in 1997 and tried to get the legislature to expand it. And they're looking at us like, what, are you crazy? We're not going to expand this. We're going to actually pass some legislation to put some controls on HOAs. And so we cannot, at this point, we have not been able to expand it to Fort Bend. And I wish we could, because I definitely would.
We need it. Thank you.
Yes, ma'am. Thank you. Good morning, sir.
Bill, I got a couple of elephant in the room statements. This would apply to you. Number one, how do you define a single family house? What consists of a family?
Well, what a family is,
No, in the law, not what we think about it.
No.
But
Well, the U.S. Supreme Court isn't even sure what a family is. They don't, because America is a melting pot, and families are different in different cultures. So therefore, they are not going to say it's a mom and dad and two kids. They're not going to do that, and I don't blame them, because with different cultures, families are different. Different cultures, like grandma and grandpa and aunts and uncles even living under the same roof, that's acceptable in that culture. So the U.S. Supreme Court really, they will not define in America what a family is.
I understand. That's one of the problems that we have. The second issue is absentee landlords. We can deal with it if the city would support it by saying if you have, for example, two renters in the two structures or domiciles in the city, you can say they're conducting business in the subdivision. But that's the only leg that we can find that will protect us from these people. We have roughly 60% absentee landlords in our subdivision.
Let me tell you what I have by you saying that made me think of this. I have an association that I represent that's up in Dallas, and they're a large community. And so what they did, they amended their restrictions, and basically they put in there, and it hasn't been challenged in court yet. People have balked about it, but they've enforced it, and they've been enforcing it now for about 3 years. But they put in, if you buy a house, you have to live there at least 24 months in that house before you can lease it out. So that's how they're combating those particular landlords. And then they also say that, you know, if you own up to 3 homes, that's fine. But if you want to buy a 4th, you've got to come to the HOA and talk to the board about it. These have not been challenged, but it is a large community, very nice community up in the Dallas area, and they're enforcing it. And we've had some realtors, you know, get on us, we don't like this, but nobody's challenged us yet, and they are enforcing it. So you may want to do something like that to where you amend your restrictions to address it in that way.
Well, I think this is more of a city thing. You can't tell an owner of a property how to manage their property as long as they fit within the city's ordinances. Problem is, A, the city's not enforcing their ordinances, and B, there's not a mechanism to deal what everybody in the city is dealing with. So everybody, all these people that have spoken indirectly, they're addressing those two issues. And until, for example, you got a bunch of people living in a house, it overloads the plumbing, so they have problems with the discharge of waste material. The streets are clogged with 40 cars, on and on and on. Dealing with multiple people living in a house and having multiple renter type establishments are the two biggest problems the city is facing, the whole state is facing. And until we figure out a way to address those two issues, we're going to continue down this path that leads to, devaluation of the city.
So can I just jump in here? So I think we have other 2 top priority issues in the city. I wouldn't argue that it's renters and multiple folks and families. Just some context. So when we purchased our homes, we didn't have the population we have at this time. We have promoted this city. We are a global city now. We have recruited corporations to come. We've encouraged people to resettle families here. But we also experienced a global pandemic where people were forced out of their homes. They were evicted. Many people moved in together. I have a friend that was out of her house for 10 months, and they had to move in with family until their home was rebuilt. But you're absolutely right. My father still lives in Brays Village East, and every time I drive down Briar Glade, I barely could get down the street. There's which speaks to delays with solid waste, because if the truck can't get there, they will not pick up your trash. And we make no questions about it, right? But then, so there was a time where the streets were clear. There was a time when everyone didn't own a car. Everyone has a car now, right? So some of the ordinance we have, and we're working really hard to enforce that. We do have challenges with personnel. With Park Houston specifically, in the last budget cycle, we approved a 4th shift for Park Houston, and overnight, 8 individuals plus a supervisor to address those things. If you park on a city street for more than 24 hours, you are violating a city ordinance. Most people didn't know that. 18-wheelers, tractor trailers, they're inundating our neighborhoods, and we get those calls all the time. However, HPD is the only department that has the master contract to tow. And, frankly, as they continue to work on priority crime, it's a delay to get to those parking issues. So what we've been working on with City Legal is for the district office, for me to designate some of my funds to address towing, immediate towing of those junk motor vehicles, cars with no tags, expired vehicles that have been on public streets for extended period of times. And I think even Kelly, my HOA president, or Nora had texted me because we have a neighbor that drives an 18-wheeler and parks on the public street. And you can't turn around and see the cars coming and the kids, right? It's a public safety issue. So I deal with it in my own neighborhood. And so we're working through that. We're nowhere near close having a deal because HPD has that contract and we have to finagle that. But again, it's those covenants have to be changed. And I think someone mentioned earlier about many of the declarations we had when the neighborhood was built in 79 or 54. I mean, we don't even live that way anymore. And so the city, we can come in if there's chickens, right? The Department of Neighborhood, Veronica and her team, when we have, homeowners that let their property go away, the health department comes in and inspects the pool. We can do the citation. But we have a homeowner in Ashton Village right now. There's a warrant for his arrest, and he refused to show up. But the neighborhood believes we're not doing anything. We've consistently cited, we've consistently tracked them down, but they don't show up to court. So we're not the FBI. We can't do that. We have limited resources, limited council staff, and these are private property. So in 2022, the city, we approved a contract with the firm to help us address deed restrictions because City Legal is so inundated with other things. But they knew that this was such a huge issue happening in our neighborhoods because many deed restrictions are expiring. So we do have some supplemental support to kind of validate and interpret those according to the city ordinances. But if you just take my deed restrictions from 1979, much of that language doesn't even mirror what we do at the city level, right? So the interpretation it's up for anyone can kind of interpret that. So those are some of the challenges we're dealing with on our end, but know that these are very valid concerns. And to the point of, culturally, we have a very international community, and culturally, it is very common for grandma and grandpa, for multiple generations to stay in the home. I think we have to marry that with how do we make sure that they're safe, city services are not interrupted, and that we can continue to maintain the property with the assessment, right? And so, but the language has to be there in order for us to do that. So we're limited in what we're able to do. Y'all are limited in what you're able to do. And then we must collectively pressure the legislatures, those that represent us in Austin, to give us the flexibility to address our issues locally, because we're the closest to the ground and we know what's best for us. But but I just wanted to say, long story, that's on the list. We're very well aware.
Yeah, let me point out one other thing, and this is, a lot of people will call me and say, hey, there's a bunch of people living in a house here, and our restrictions say single-family residence. Well, the Texas Supreme Court says, when it says single-family residence, it's not describing the individuals who live there. It's describing the type of residence that's there. So just because it says single-family residence, they're talking about it's not a condo, it's not an apartment complex, it's not a townhouse, it's a single-family home. So they will not interpret that as only a single family lives there. And even if it did say in your documents, only single families live here, then we get into what's the single family, and I don't really want the courts telling me or anybody else what a family is. Because each, and I'm not, proposing that have 15, 20 people living there and everybody saying their family, but if somebody looks on and grandma and grandpa need to be there and that's part of their culture that they take care of them, then they should be able to do something like that. So that's why the courts won't touch that. Yes, sir.
Okay. I'm Steve Smith. I'm here for a representative that was out of town today, couldn't make it for Brookfield East. His questions he had asked me to pose, and I think we have touched on several of them, but I'm going to go ahead and go through with what he asked. Said, if the group homes are not monitored by the city due to under 3 paying residents, how do we determine if they are simply renting out rooms or if the residents are under care? Renting out rooms can be fought by our attorneys, and if the residents aren't getting care, it is simply a business from home. Can the HOA rules of single-family dwellings apply to group homes where residents' rent is being paid through Medicare or Social Security or probation like city, county, or state being disallowed? If HOA rules state no business and only single-family dwellings, aren't homes owned by investors and rented to groups who are using them for group homes able to be prosecuted? Our attorney says no. Is this correct?
Your attorney is right. Here's the problem. The state of Texas, and there's case law out there, and the main case is from Cleburne, Texas. And essentially what the legislature and what the courts recognize, because of what the legislature has said, when you have a group home that's taking care of the handicapped or the mentally impaired or anything like that, they will usually be registered with the state of Texas as a group home. They'll have a license. And the courts and the legislature says you cannot kick them out of your neighborhood. But usually how they're set up is they will have, let's say, 2 individuals to a room. They will have what we call a house parent, one that stays during the day, one that stays at night. Meals are cooked for them. They're supervised and everything. But the legislature protects them and says they have the right to live in a neighborhood like anybody else. Usually you don't even know unless you live there. You don't notice it when you drive by. So they're very much protected. With regard to somebody else renting out rooms and stuff like that, and the reason your attorney's saying no is because of Tar versus Timberwood, you're going to need to amend your restrictions to address those type of situations, and it can be done. However, it's the Texas Supreme Court spoke loud and clear to everybody. We want to see it in your restrictions, because in Tar versus Timberwood, they argued that this was a business. This Airbnb was a business, and the Texas Supreme Court didn't buy that argument. They said, we want to see it specifically in there so that when somebody buys a home in that neighborhood, they know what they can and cannot do. So we have to have it specifically stated in the restrictions what you want to stop. And that's why your attorney said, no, we can't do it based on how the restrictions are written. You're welcome.
Part of my question until his question. I'm Linda Shank, and I'm with Huntington Village. You mentioned that, now I've lost my question. I'll go to my other question, maybe I'll think about it in a second.
Alrighty.
Okay, the bill that Tiffany Thomas talked about, Senate Bill 412 has passed, or 1412 has passed, and real quickly it said homeowners can build an additional dwelling unit on their property, like a mother-in-law suite or garage apartment, that could then be rented as a way to create more affordable housing, and it goes on and on and on. So it's already passed our Senate, it's probably going to pass in the House. That seems to me that our deed restrictions, parts of our deed restrictions will be null and void. In our neighborhood, to change or amend our deed restrictions, we need about 1,600 votes.
Wow.
Yeah, we have a small addition. In any case, so, we're not going to get 1,600 votes. So how do we deal with our current deed restrictions if, in fact, this happens?
Do y'all have an HOA and
Yes.
mandatory assessments and stuff?
Yes, I'm on the HOA board.
And the thing is if that's passed the Senate, it's going to go to the House, there still may be changes to it. And what I would do if I were you, get in touch with your representative in the House. let them know we're concerned about this. The more people who call and tell them, then the House basically, they don't have to take what the Senate gives them. It will be in their committee. They can make changes. And so the best thing to do is, and I'll pull that up and look at it and make my associations aware of it and say, we can't live with this. We have a problem with this. So the House can change it. And then it has to go to a committee with the House and Senate members and see if they can agree on the changes and what would be approved in both chambers. So the game is not over yet. Just because the Senate's approved it, get in touch with your representative from the House and say, this would kill us if we allow it this. And what you can do is, if the whole thing's bad, tell them the whole thing's bad. And not just you, but get other people to call. We did that one year so bad that one of the senators said, stop it. You're bugging me to death. You're jamming my fax machine. I'm getting emails like crazy. You're ringing my phones off the hook. I get it. I know what y'all want. That's what you need to do. They've got to know that you care. And if they know their constituents care, then they're not going to vote in favor of it. So that's what I'd recommend for you.
That's a great recommendation, and I will even call our local AARP group to see
Yes,
if they can
ma'am.
get involved.
Absolutely.
Okay, but let's pretend like it does pass. So then what happens to our deed restrictions?
With regard to that particular issue, and from what
It touches on many issues within our
Right.
deed restrictions.
what's going to happen with that is essentially, as an association's attorney, I would look at it and say, okay, everybody, here's what's going on. Here's what we cannot enforce, and here's what we still can enforce. Keep in mind, the way they write things, there's always some kind of loophole in there, and attorneys will push the limit
Okay.
with those loopholes. So don't give up. We haven't seen the final wording of it yet, and that makes the difference. Is it an and? Is it an or? Is it a shall? Is it a may? All that makes a difference. So call, since it hadn't passed yet, get your AARP, get word out to everybody in your neighborhood, anybody else you know, and we can do something about it. There's still hope.
I remembered what this.
Okay?
We have a house that's on my street that does care for people who are ill from whatever reason. However, they are not registered. They do not have an application in-house or anything. So what can we do now because they're not registered?
Have you, and do you know if they're caring for, let me ask you something, because you're still going to have I've run into them too where they're not registered with the state of Texas. So we send them a letter. I've sent people letters and said, we see that you have people living there. What's going on? I reach out to them to find out, because even if they're not certified, if they're basically following the law and not certified, the courts are not going to shut them down just because they're not certified, because that case is very broad and the case law after it is very broad. But you have the right to find out what's going on, and especially if I've run into problems where they're not supervising the people who live there. They're getting out, they're wandering around the neighborhood, and neighbors are just concerned because they can get hurt and they can get lost. So we reach out to them then and make sure you're supervising these people. So it's really also looking out for the residents who are living there, since they can't look out for themselves. So reach out to them.
You do know they admitted to us that it is a house. So I was just curious. I think we have it already with the city, and I was just curious if we probably go to an attorney next or something. So anyway, but they're careful. They do a good job. Unfortunately, they're not registered. Thank you
Yeah.
so much. I appreciate it.
Thank you, ma'am. Good morning.
My name is Carolyn Boozer, and I live in a subdivision called Carver Crest. It does not have a formalized HOA. We have a functioning civic club. We have deed restrictions that date back to, I think, like 1953, 54 timeframe. The deed restrictions were pretty basic in the sense that It says it's single family, it's a single family residential. It is, it has setbacks. It has minimum lot size. Let's see, among other things. However, I guess one of my first questions, perhaps it piggybacks on what some have asked, is the definition of single-family residential. I'm not talking about the people. I've been reading that it could include things like I think you mentioned, like a granny flat or some other living unit on the property. And that's still single-family residential. So is that true?
Well, here's what the courts would do, because every neighborhood is different. So they would look at your particular restrictions, and in the restrictions, it should describe, you know, here it's a single-family residence, and then it'll describe the square footage, all that kind of stuff. It'll have a garage, a driveway. If it doesn't say, and it'll also have, you know, a house in the back or something like that, they're not going to read that into it unless the legislature does something, but they're going to look at your particular neighborhood and how it describes what is a single-family residence. Because your neighborhood is different from a neighborhood, let's say, in Tomball, Texas, you know, where they have acreage and stuff and they allow different things. So they're going to look at what does your deed restrictions describe as a single-family residence.
And can I offer color in some lines? So what's happening right now, many of you have probably heard or read in the newsletter, the Livable Places Initiative. Have y'all heard of the Livable Places Initiative? It's highly important. The Livable Places Initiative is addressing housing affordability and some of your concerns. The Planning Department is proposing a series of changes to Chapter 42. They are defining it as the missing middle of housing, which allows that additional unit on the property, like the granny house or the mother-in-law suite or whatever, you know, all of those. And that is coming up on the agenda fairly soon. And so we're going to need input with that. It's been in a couple of our newsletters. I will make it a point, and Ken, if you can make a note, I'll do a special call newsletter with the information in the FAQ of livable places, because what that will allow is up to 1,900 square feet, I believe, on property. And your neighborhood is a little different, and this probably has more land, and y'all have the lot size to do it. And when I briefed with them, they were asking about feedback in the district, and I immediately thought of Carver Crest because y'all have very large lots. And so that's something that we need to get ahead of in terms of documenting your comments, because this is apparently, from what I'm hearing, already happening. And so there is a proposal to amend that ordinance to allow this middle housing to happen, which includes that 1,900 with parking. Some of the builders are against the amendment of Chapter 42 because it forces more parking on the street. And we already know the issues we're having with street parking in our current condition. So I want to raise that to you, help color in those lines, and let you know what's coming to council in a couple of weeks. And I want to get your feedback on that, because to her earlier comments of the senator, your public comment and your real life experience helps us shape those ordinances. So it's really critically important for you to contribute to that, and we'll make sure we get that back out to you.
Since we do not have an HOA, and you know, we rely upon the City of Houston's deed restrictions section to help us, and they've been helpful in some instances. In other instances, they will say, well, we're not going to enforce that particular restriction. So I guess one of the questions is, going back to single-family residential, the city has said to us, and I don't know if this is true or not, because we do know the city is inundated with a lot of other issues, but the question is, if a property owner is running a business and they live own property with that business, they can continue to run that business if they live there, whereas the deed restrictions say single-family residential.
Do your deed restrictions forbid any type of business?
Yes.
Okay. Never heard that line of thinking. Just because they live there, because most of them do live there when they're running their business from their home. That's the first time anybody's ever used that type of argument. And essentially what the courts do is if y'all enforce your restrictions and you stop people from running businesses and you haven't waived that restriction, then the judges enforce it. If we can prove that they're running a business from there, and usually you can nowadays because of the internet, the website, and all that kind of stuff, or you have traffic coming all the time, they're going to enforce it. And they will stop people from running a business, whether they live there or not. They stop them from running businesses because most people who do have a business in their home do live there. So I've never heard that line of thinking.
Okay. Because this has gone on for a fair amount of time, I guess I'm concerned about the issue you mentioned about waiver. I mean, we've complained about it. We got a response that says, well, we're not going to do anything about that. So
What they do is like with waiver, let me give you an example of what the Court of Appeals have said. When they're looking at waiver, there's case law out there that says if we look at your neighborhood and let's say you have 160 homes in the neighborhood, if we see that more than 2.5% of all the homes in the neighborhood are violating this type of restriction, then we consider it waiver. And some courts have even allowed you up to 8.5% of all the homes violating it. So the case law kind of jumps from 2.5 to 8.5%. But if you're below 2.5%, let's say you had 5 people who had businesses in their home, that unless you had a 6-home community, then you'd be in trouble. But if you have a 160-home community or 200-home community and you have 5 that are running businesses, you're not going to be in trouble with waiver. The courts are not going to say, yes, you've waived that restriction based on what the Court of Appeals have said about waiver.
One other question. We sort of rely upon workshops like this to get information, rely upon the city. We've not formed an HOA, so we ask a lot of theoretical kind of questions. So in amending deed restrictions, our deed restrictions say we're in the stage now that they automatically renew every 10 years.
Yes, ma'am.
And so I'm kind of confused as to what that really means. You know, if someone wanted to amend them in year 5 of that 10-year span, could they do that, or do they have to wait till just before the 10-year period expires?
Well, you've got good company because attorneys have been confused about that, and so have judges in the courts. However, here's what you look at. If it says our restrictions renew every 10 years, that's not limiting you on when you can renew them. What you need to look for in some restrictions, and they're few and far between, but in some of them they will say you can only renew it on the 10-year, you can only amend it on the 10-year anniversary. So if it says that, then you're looking at the 10-year anniversary. However, you have a section of 204 of the property code that says that's null and void. You can amend it at any time, but remember 204 only applies to certain counties, but if you're in Harris County, you're okay. So even if yours said that, we can use 204 of the property code and says, no, they can amend it whenever they want to. But so watch the language very carefully on when it says to amend. But if it says they renew every 10 years, you can amend yours at any time.
Okay, last question. Going through an amendment process, we don't have an HOA. We've been told that there's a process that says, you know, it's a very extensive process where you set up a committee, you announce the committee, you do there's multiple writings, certified letter writings to the residents, the property owners, and it runs about 2 years to amend deed restriction. Then someone said, well, our particular deed restrictions have a simple majority of the property owners to amend. So if we were changing the deed restrictions, would we have to follow that very lengthy process?
No.
Or the little short,
Your
getting
short
a majority?
process. Yes, ma'am, the short process, because your restrictions state that. Your restrictions state all you need is a majority to amend. So you and a group of other homeowners that are concerned about this, y'all can hire an attorney, get the amendment written up, get a ballot written up, and have meetings, call meetings with the homeowners, and then tell them, here's what we're going to do. Get some ideas from them. They may have some great pointers on, hey, we need this and in that too. Then get as many volunteers as you can to go out, distribute this. You're going to need to mail it to everybody. And if people want it emailed, email it to them. And you're going to have a lot of people will respond back, but you're always going to be a little bit short of that number. That's when you have to look at a list and say, okay, we need to contact this person and this one, we didn't get a response back. Most of the time people are in favor of it, they just get busy with life and forget to respond. So, but the good thing is people can email the ballot back to you once you reach that 51%. And I always like to go a little bit over, because you never know if somebody really owned that home or not. You may have a question about one or two of them, then you're done, and you file them in the property records. So go with the short version.
Okay, so we've talked about updated deed restrictions. So where could I go, or our Civic Club go, to find language for the most updated deed restrictions?
If you call me, and I will email you some updated deed restrictions in other neighborhoods, and now they may not, everything in there may not fit your neighborhood, but you pick and choose what works for you.
Okay. Well, thank
All righty?
you. Appreciate
That
it.
way you don't have to recreate the wheel.
Yes, thank you.
All righty.
I just want to say Ms. Barber is going to be our last question, so we have some time in between our programming.
Okay.
Good morning. My question regards dissolving HOA. I need specific information on how to go about it, because these questions were posed to me. I am a board member, but some of the homeowners mentioned that we needed to dissolve. I kind of agree with them. So we could either get so much percentage of the homeowners to agree, or we're looking at not having enough money to meet our expenses. This is the second year we've gone in the red. Or let it go that way, then we have to file bankruptcy. But I don't understand, something happens if you do that, but because we still believe we need an association. So can you guide me?
Yes, ma'am. What are your current expenses? Are they like street lights or
No,
trash?
just maintaining. We're not maintaining our amenities. We've closed the playground. We can't finish the flooring in the clubhouse. We did some repairs. The pool, you have to keep up the pool. We have a tennis court that no one uses that is totally, totally worthless, and it's dangerous. We can't fix these things. If you don't maintain these areas, they just get worse, which is why our expenses are so high, okay, at this point. We had to spend $52,000 to get a pool done because our present board members who've been on here 40 years and homeowners didn't care anymore because their kids are gone.
Right.
So they just let the areas deteriorate. So we come in now, we offer these amenities for the people, new homeowners, but they can't use them. So we need to dissolve this board, or just let it, I'm the treasurer, or just let it go every year. Our maintenance fees are $96 a year.
Can you raise those?
we can't without getting 67% of the homeowners. Well, we had a meeting for reelecting some board members, and I posed the question to those members that attended. No, they're not going to do that. They would rather dissolve it than to raise those dues, and we are only asking to raise it to $200. That $92 has been there since 1975.
How large is your neighborhood?
I'm sorry.
How large is it? How many homes?
720 homes. And mind you, all of those people don't even pay the $96.
Wow. So would they, I mean, the thing is before you shut everything down, I'd send out notice, emails and stuff, and just let people know, here's where we are. This means the pool, the tennis courts, everything's just gone. We don't have any more money to spend on it. They should be concerned about that because of what it will do. I mean, if you have those shut down, that can hurt the value of everybody's home. And I understand your concern. I had another neighborhood one time who they drained their pool. They couldn't afford it anymore, so they drained it. They didn't have the money to fill it in, so they just drained it. And y'all may get to that point to where you just drain your pool and get somebody to fill it in with dirt or something like that. So that way nobody can fall in it and get hurt and then sue you for that. But
Well, I don't think they're going to do that after we just spent $52,000 to revamp that pool. But we can't open it because it's hard to find lifeguards. Now, we realize we can't put up signs that say swim at your own risk. No lifeguards on duty. But
yeah, you can put that up. Other associations do that. But you want to make sure you have insurance then.
We have insurance.
Yeah.
Too costly.
I mean, bankruptcy, I wouldn't do that. Y'all don't need to go into bankruptcy.
We're going to if we don't have the money to pay your light, water, make necessary repairs.
So are y'all having to pay for, with regard to the pool, what does it cost you like on a monthly basis?
That's running like over $1,000, I think, if that's it. Plus we have security that we did put part of that fee onto the homeowners, but we switched security companies. Now we're over budget for that. And I don't think, our homeowners now just don't care anymore, I don't think. They just don't care, they complain, but they don't want to do anything, but they complain. The only reason I'm here now because a few of the homeowners talked to me, because I'm on the homeowner side. The board needs to be disseminated. I don't want to say all that, but but we don't want to be without an association.
Right.
So I guess if we just dissolve it, if we get the homeowners to agree to let's just dissolve it, even though you got to get these board members to sign something saying, but we need to regroup another board though, because we'll end up a slum.
So you want to basically are y'all in favor of get rid of that board and getting a new board in place who does care and will? Okay, there's ways to do that. And you don't have to are they holding regular elections?
We just had a farce of an election last week.
Okay, here's what usually in your governing documents, and this would usually be in the bylaws for your HOA, it will state in there a way to recall the board members. And so what you would need to do is, and if you'll contact me, I'll tell you exactly in the bylaws where to look, but essentially y'all could pass around a petition, and it's usually 10% of the homeowners sign a document, just a petition stating, we want to have a special meeting of the members to recall the board members. And you sign that, then the board is obligated under your bylaws to schedule an election, a recall meeting, to where the homeowners can then vote, and it'll tell you what percentage is needed to vote, what percentage is needed for quorum to get rid of that board, and you remove the whole board at one time. So there are ways to get rid of them. And you know, a lot of board members, if you do that, they don't want to go through that humiliation, so they'll just step down.
Oh, no, sweetie, not these board
Well,
members.
then they can be subject to humiliation.
They've been on this board for 40 years or more. We have no term limits, which I think we should.
Well, your document should state in there that you can only serve for like 2 years or 3 years.
Doesn't. That's what I'm saying.
So there's nothing in there. Once they get on the board, they stay for however many years that they want.
Unless they die or they're voted off. And as soon as we've had 2 to pass, they get somebody right on there, right away. You don't even know it. Hold a meeting.
Right.
No election committee. This person wants to be on the board. All in favor, aye, they pass.
Well, what you need to do is
Get off the board.
give me, would you give me a call and let me look at your bylaws, because there's usually a way in there, and we can find a way to help you with that.
All right. Thank you.
All righty?
Yes.
Yes, ma'am.
Everybody's dying to be a board member, right? No more thankless job in the world. My name is Barbara Quattro. I live in Brays Village. We have 986 homes in our subdivision. We do have some group homes. But I want to know if we have the right to ask the homeowner for if they have a license or a certification.
Yes, we ask them. Absolutely.
But can we as a board write them a letter and say you have to produce this?
Yes, ma'am, you have the right to. And also, we've even checked with the state of Texas. If you know the name, like, do they have a name for their group home? If you don't know that, ask them. Say, what's the name of your group home and what's your license number with the state of Texas?
One of the residents in one of the houses told me, I was out doing deed restriction, looking for violations, and he told me that there are people in that home. I don't think it's licensed, but they're not mobile. In case of a fire, there's no way for those people to get out of there. So we think it's a dangerous situation.
Oh, yeah.
So, but we do have the right to ask them to
Yes,
produce it.
ma'am.
Okay. I want to.
And if you think, I'm sorry to interrupt you, but if you think that that's a situation, I would get in touch with, I'm sure the city fire department has a way to come and inspect a home, especially if it's a group home for individuals that are handicapped or have mental disabilities. Have the fire department, have the marshal come and check that and make sure that they're complying, because you don't want people to be jeopardized. Make sure that they can get out. They know how to get out. They're in compliance with the city. I definitely would do that. And you're not in trouble for doing that. That's looking out for people.
The guy that told me was living in the garage, and they would let him come in maybe once or twice a day to go to the bathroom.
That's not right.
No, it isn't. Our deed restrictions have some god-awful clause in there that in order to change the DCCRs that we have to have, 75%. We are a very diverse neighborhood, and we can't get 75% of the people to agree on what day it is.
Right.
So, can we, as I understand it, can we have them rewritten and then ask for a vote? Is that how it works?
Let me ask you something. You're in the city of Houston?
Yes.
And do you have mandatory assessments?
Yes.
And your HOAs mentioned in your restrictions?
Yes.
Then we don't need to mess with the 75%. We can use, we've got 204 of the property code and 209, and they refer to 67%. So we can lower you down with regard to those two statutes, because they say if you're above this 67%, you can use 67%. So we can actually use that percentage, and you're going to need the owners to approve it. Okay, you're going to need 67%, and it may take a while, but if you keep at it, I've seen large communities be able to do it.
Well, persistence is our middle name, but
there you go.
It might take years. Also, you mentioned earlier to the last speaker about the term limits. Our deed restrictions had term limits, but then I think it was CAI told us that the state of Texas nullified.
No, here's what the state of Texas did not nullify where it says if you know, the director will serve for 3 years. Each director will serve for 3 years. They didn't nullify that. What they nullified is you not being able to say somebody cannot run for the board. Okay? Here's what they're looking at is the state did not touch the fact that you have restrictions that say somebody can serve 3-year terms. What the state wants is you to be able to say you can only serve for 2 terms and then never serve again. That's what the state's addressing. Like term limits like the city of Houston has for their mayor and stuff like that. You can't have those particular term limits. But people cannot run and get elected to the board and say, now I never have to run again. They have to, because you've got other sections of 209 of the property code that says once your term expires. So if you're elected to a position on a board and it says that position is for 3 years, once your term expires, you have to be reelected. You cannot, a lot of times what happens is with HOAs is they can't reach quorum. And so therefore, they say, hey, we couldn't reach quorum, so I'm going to stay on the board. No. The 209 of the property code says once your term expires, even if you couldn't reach quorum, you're done. You're off the board at that point in time. Until you reach quorum and have another election, that person can run. They can run for as many times as they want to run. But the term is for 3 years or 2 years, depending on what your documents say.
Well, people standing in line, at least in my subdivision, to be on the board, right? Because it pays so well.
Oh, I know it.
Yeah,
Yes.
It pays so well, and everybody thinks highly of you. So, also, another question. We're self-managed. We have an office manager, but we don't have a management company. We've tried that a couple times, and we don't find it effective. And we find that we do better. But a lot of law firms won't take our deed restriction violation cases because there are a lot of people we would like to sue because they're not maintaining their property. And we've been told outright, okay, you're not managed by a management company, so we won't take your cases. So have you ever heard of that?
This is your lucky day.
Okay.
Because I represent a lot of self-managed communities. It doesn't matter to me who it is. If I've got people who are enforcing their restrictions and they're self-managed, we represent them. They don't have to be managed by a management company. So why somebody would say that to you, I don't know.
They don't like our money, I guess, but they...
Yeah, but you call us and we will be glad to represent you because I have numerous self-managed associations from small to very large. The one I was talking about in Dallas earlier, they're self-managed, so.
You'll be hearing from us. Thank you very much.
Thank you. Anybody else have any questions or anything? Yes, sir. And then I'll get this lady.
Didn't stand in line because I don't stand too well.
Okay.
We have a fine system that we did an amendment on, whereas for restrictions, violations, we can fine people. What's our minimum period of time after a violation occurs that we can actually submit a fine to that
What you've got to do is, and your restrictions specifically state you can fine people.
That's
Is that correct? Yeah, and I want to point that out to everybody. It's got to be in your restrictions saying that you can fine people for that particular type of violation. And yours may say, if it broadly says the board can establish fines for deed restriction violations, then you're fine. That's a very broad statement that the courts will enforce. What you need to do under 209.006 of the property code, it says before you assess a fine, you have to send somebody notice what the violation is, give them a reasonable time to correct that violation, and let them know that within 30 days of the date of the letter that they can contact you and have a hearing before either your ACC or the board. And then if they contact you, have a hearing with them. If they get it worked out, then you don't have to assess the fine. If they don't contact you, then after that 30-day period is ended, then I would you can start assessing that fine. But give them that right to a hearing. Otherwise, the courts will never uphold that fine.
Right. Understand the hearing part. What my question is that reasonable time. One of the main violations that we have is people putting out heavy trash at the wrong period of time. And if we have to wait 30 days to fine them, trash has already been picked up. Then 4 or 5 months down the road, they'll do it again.
Well, here's what the exception is, and there's always an exception, is in that particular instance, that's if they're putting out heavy trash, then you can try to go after them from a standpoint of, we're going to go get a temporary restraining order against you or a temporary injunction. Then you don't have to comply with the hearing requirements under that particular statute. And that's under 209.007 that says that. If you're going for a temporary injunction or a TRO, the hearing requirements of 209.006 don't apply. So a temporary restraining order is like that particular instance. Somebody puts out heavy trash and it's not going to be picked up for, say, a month. Our clients will contact us and we will have a letter hand delivered to them. Get rid of that heavy trash by tomorrow at noon, or contact us about this particular letter. If we don't hear them, we tell them in there, we're going to file a lawsuit against you for a temporary restraining order, which is something that is then filed within the next 2 or 3 days. We're before a judge 2 or 3 days after we've sent that letter, and we're telling the judge, here's a picture, here's where they're violating the restrictions, and we want you to order them to remove that trash immediately, which they'll sign an order, we get it delivered. Now you've got a judge who says, get rid of it now. And so that's how you combat and get around the hearing. That costs money. I can tell you.
That's what we're trying to avoid. The whole reason for us to implement the fine system was to try to not take it to legal. But by sending them a fine, we're minimizing the cost against that particular individual. So my question is not necessarily taking them to court. The question is, how soon can we send them a fine? We send them a letter first to indicate that they've got the heavy trash, they need to address it. They don't address it. So how much time frame is considered a reasonable amount of time?
With that first letter, you may want to give them 10 days, unless your documents say something different. Make sure your documents don't state.
Doesn't address time.
Okay. Give them 10 days and say, you need to get rid of this. Then immediately, if they haven't, on that 10th day, send them that letter that complies with 209.006 and say, here's the reasonable amount of time you have to get rid of this, and we're going to start assessing a fine, and also you have the right to a hearing. Let them know that. But then after that letter expires, that 30-day letter, you've got to give them that 30 days to contact you for a hearing. Start assessing those fines. And I don't know, yours may be daily or whatever, but they can add up quickly, and hopefully they'll pay attention.
Right. Now, from some of the questions came up was about finances, not being able to increase the assessment.
Yes, sir.
Because of the, can you address the community service fee for everybody here, what the community service fee is?
Such as, are you able to increase your assessments?
Right, that the board has the right to increase.
Usually usually the documents will state that the board has the right to increase it up to 10% over the amount of the previous year. If you want to go higher than that, then it's usually stated 2/3 of the community is going to need to state that, okay? And they're going to need to approve that, I'm sorry. So if you want to go higher than 10% in your assessments, then 2/3 of the community would have to approve that increase. But y'all have the right to go up to 10%. You may go up 1%, you may go up 5%, 8%, whatever that may be.
Okay, thank you.
All right. That lady had... Oh,
and we're just
okay.
can everybody give Rice and Rice a hand of applause? Thank you so much.
Thank you. Thank you very much.
Yeah, so we've got about 10 minutes before our next event, our next programming will be right here.
My name is Nora Luna. I work for CenterPoint Energy, the energy efficiency program. I'm one of the program managers. We offer incentives to weatherize your home. And I have more information at the table. We're also offering a free AC tune-up. All you have to do is scan that QR code or get the link, our website, page, and you can go and read it. You register, and CenterPoint within 3 to 5 business days will send you the vendor, authorized vendor that has been authorized to work on your home. You schedule that appointment, and they will come and do a free AC tune-up. That's all I have. If you need any information on energy efficiency, just come by my table back there. Thank you so much.
We're here today to talk about contractors and preventing contractor fraud and how to pick and choose a good contractor. So I have one of our residential lending experts that are here to talk to you today. So I'm gonna give the mic to Chris so he can get started.
Good morning. I'm Chris Williams with Frost Bank. I am one of our consumer residential lending officers, and we're just going to go over a couple things about how to choose a contractor. Oh, can't hear me? Is that better? All right, no problem. So we do home improvement loans here at Frost, so we're going to talk a little bit about how to choose a contractor. So you want to do a remodel project, things like your kitchen, your patio, maybe even adding an extra addition, closets, just change the way your house looks in general. We're going to go where to begin, how to plan it, how to find a qualified contractor, and some things about never paying in advance. So first off, you definitely want to do your research. You want to make sure that the contractor is actually a licensed contractor. They've been in business for quite some time. You want to look at your references, online references, check the Better Bureau. If they provide you references, make sure that you are able to follow up with those references. Obviously, they're going to give you references that are good. So you can do Google, you can ask to see pictures of their completed work. They should have a portfolio that's available to you to review their work as well. You want to make sure that it's up to your standards. Create your own assessment pool. So who are you talking to? You're going to be talking to the owner or the representative, or you're going to be talking to somebody in sales or somebody in design. If you're talking to somebody in sales, obviously their goal is to sell you. If you're talking to somebody in design, they're going to be able to give you an actual better breakdown of what the project is going to be consisting of, what you're looking to do, and how it works. Accept their references, but always do your own research. You can look at things like, I don't know if you're familiar with the Texas Secretary of State. You can look at that. You can see how long they've been in business. Visit their office. If they're working from their home, that may be a red flag for a contractor. If they have a workshop or if they have a business or an office, ask to visit that office. You want to look and see what it looks like from your point of view. Is it clean? Do they have materials there that you can review? What regions do they work out of? Are they from San Antonio? Or are they from Houston? Are they from Austin? Because if you want to make sure that the contractor that you choose is going to be providing work to the region or the community that you live in. Be aware of these storm chasers. If someone is, the guys that knock on your door after a big storm, those aren't the contractors that you want, because those guys, they go from neighborhood to neighborhood. You want someone that specializes in what you're looking to do. And trust your own judgment. Make sure that if you're looking to do a pool, don't go with a contractor that does siding. You want to make sure that you have someone that's doing the right thing for your project. So you'll always want to know what they specialize in as well. Business experience and methodology. Ask for their permitting addresses. You can ask for the contractor's insurance, who the subcontractors that you're using. You should always get a copy of a written bid and the insurance at the same time. The insurance should come directly from their insurance agents, not the contractor themselves. There's this great thing called Adobe. They can always make that up. So you want to make sure that you get an actual copy of the insurance. See how long they've had it, see how long it's going to be good for. Did it expire previously? Also, with the Texas Secretary of State, you can check and see when their business entity documents were filed, if they filed them, if they've paid their business taxes, if they've let their entity documents expire. You want to look at those, because that may be a red flag, because a lot of times there's contractors that are continuing doing business, but they're not an actual business. So we do check those at a certain point, but not always. So that's definitely something that you want to make sure that you're able to look at. Sorry, yes, ma'am. And what trades do they ask for? So like, again, are they doing pools? Are they doing remodeling? Is it siding? Is it going to be for pavement? What type of work are you looking to do? For plumbers, electricians, and air conditioning repairs, always ask for their entity docs and their licenses and insurance. So where do you look? You can look at advertising. If you have a community neighborhood newsletter, Google, any websites. We have social media these days. Everything's pretty much on there. Nextdoor, trade associations, signage, churches, HOAs, relatives, friends. You always want to make sure that you are asking someone about the particular contractor that you're looking to work with. See if they've had experience with them, or see if there's someone that you personally know that have had experience with these type of contractors. How to pick your contractor. Make sure it's going to be accurate and complete work. If you are looking to do a specific type of work, make sure it's going to be affordable. Ask for a receipt, licensing, and disclosures. You should never sign anything before you've had a chance to review it, at least 24 hours to review it. Make sure it has all your specifications in it. If there are going to be any additional miscellaneous fees, contingency fees, you always want to make sure that you're aware of those items listed in your bid. Make sure that there's a satisfactory schedule. If they say they're going to get a project done for you in 6 months, but they have 8 draws on that contract, how many draws a month are they going to be taking? How many months do they actually expect it to take with all of these? So you want to review all of those documents before you sign it, and get a competitive bid. Never just choose the first contractor you work with because the price looks right. You always want to make sure you get a couple bids from a couple different contractors. We always recommend 3 because the lowest bid's not always the best bid. You may have someone that can do the work for a little bit higher, and the quality of the work is 10 times better. So you always want to make sure you get a couple bids and review that and make sure it's up to your standards. Estimates and bids. So your best option, you always want to make sure you get a few bids. Never choose the first one. Always avoid buying materials yourself. If the contractor has in there, well, you buy the materials, I'll do the work. Why aren't they buying the materials? Are they not able to buy the materials and do the work and get paid after that? Or if they're making you front money to get the project started, that may be something to look at, because what other businesses or what other projects have they done? Why can't they support the part of buying the materials and then getting paid after the work has been completed? Also, never pay up front, never pay in advance. If a contractor asks you for more than 10% as a down payment, that is a big red flag. Here at Frost, we do not let customers pay more than 10% as a down payment because there's no reason why you should need that much to get started. And if the contractor does require you to pay that much, there may be something else going on behind the scenes where they're trying to cover a different project, or there's a reason why that they aren't able to provide the work to get started. Get everything in writing. Always have it on the contractor's letterhead. If it's going to be emailed to you, make sure it's emailed from your contractor's email address, from the business email address. Make sure there's specific scopes. So if you've agreed to get a closet redone, make sure that the scopes of that work is listed and broken down in your contract, and make sure that the pricing is also broken down in there. If they're going to be doing faucets, make sure you get the price per faucet, all of that. If there's going to be any change orders, or if there's going to be some unexpected fees added in there, like contingency, which means you sign a bid for $10,000, but you never know what's going to happen. So you have a contingency of $5,000. Make sure that the contingency is specifically listed for the fact that there may be some unexpected work not to be included just because, and then you owe $5,000 because they decided that, hey, it's in the bid. So you definitely want to make sure that you check all of that before. You also want to make sure that you do get a waiver of lien. So a contractor, if you're paying them directly, they can go file a mechanic's lien on your property, and which means that they will have a lien on your property until you've been paid. So as you pay contractors, you can always request a partial lien release that says this part of the project has been paid for. We do not have a lien for this amount. Educate yourself on the Texas Property Code. Read up about it. Here's a couple of resources that you can use. Also, you can look, again, you can use the Texas Secretary of State website to make sure that the contractor's information is listed and they are an actual entity that's paying taxes and all that with the Texas Secretary of State. Communication, always communicate with your contractors. Set reasonable but specific guidelines, get a schedule. A payment schedule and a work schedule should always be listed in the documents that you sign. You never want to sign anything without that because they'll tell you that they'll complete the project in 6 months. You're a year down the road and your project hasn't started yet. So you want to make sure that you do get all that in writing. It's signed by you and the contractor, and that it's talked about before the project has started or before you provide any type of funds to the contractor. Avoid communicating directly with the workers. You don't want to communicate with any subcontractors or anything like that. You always want to have your point of contact with the business that's doing the work, because the workers will tell you something and then the contractor will tell you one thing. So you always want to make sure that you have one specific contact and that everything is relayed through that person. Beware of familiarity, do good business and avoid preferential exceptions. So just because you feel good about this contractor, they've done good work, they've made you feel good about the work, don't let them off the hook. Make sure that everything is still in writing. Make sure that you are looking at the work that's being done. If they're using subcontractors, make sure that they're paying their subcontractors. Subcontractors can also go put a mechanics lien on your property if they're not paid, which means that if you do decide to go sell or refinance your property and you find out 10 years down the road that you've had this mechanics lien on your property because your subcontractor that fixed your closet door wasn't paid. So you always want to make sure that you're aware of who they're working with and where those payments are going. There's a little bit more about that. The way it works here at Frost, so if you have a loan that's over $100,000, we're going to do draws for you. So we're never going to let you pay the contractor until the work has been completed. So the contractor is going to sign a form, you're going to sign a form, and then you'll pay the contractor after they've done a particular set of the project. If the contractor is not willing to sign that form, it means that they're probably not willing to do the work correctly because there's documentation that shows that they said that the work was completed. A smaller contractor may be your choice, but if you are working with a smaller project, obviously do not pay all the funds up front either. Ask for a payment schedule. If they're not willing to provide you a payment schedule or work with you on that, there may be a red flag going on there somewhere. Make sure the contractor is paying for the materials. So again, if you're doing a siding project and the contractor says that it's going to cost you $5,000 to get your siding, make sure that they pay for that and make sure it's added in the bid and that you're not having to pay for that out of pocket. All work, including any touch-ups and all that, should be done first once the project is complete. And make sure that that's listed in there too, that they have a certain amount of time to come back and complete anything that needs to be completed, such as touch-ups, follow-ups, if they need to do anything like that.
May I jump in here and add to something? So every 2 weeks or so, the city, we provide a permit report. So you can see all of the active permits in the city and particularly in our district. So if you are having work done or you notice that there's work happening in your subdivision, you can always check against to make sure that those projects are permitted. If those projects are not permitted, and oftentimes that's how we receive inquiries in the office, because people notice activity happening, there's no permit, that allows us to escalate and create an investigation, but that also can serve as a safeguard to you. If you have a contractor that's doing work, we have a resident in Tanglewild, they had an extension done on their home or a project, and the contractor did not permit their home. None of that work was done. So we had to work backwards. She's lost money, a lot of time, a lot of frustration, and then to navigate the city process. So those tools are readily available. Periodically, we put that in the newsletter, but that's always a great tool, that permit tracking, so you can make sure that your contractor is permitting the work that's happening in your job. Yes, ma'am. Yes. Yes, and so if you have neighbors that decide to pour concrete over their grass to create an extra parking spot, which happens all the time, that needs to be permitted, and that would more than likely not be approved. So just to let you know, if that has happened, there was an incident in Imperial where that happened, and they were trying to make the driveway ADA compliant. Right, their father was disabled, but they weren't permitted, and so we had to work backwards with them to make sure they were permitted and that they met the city's code because of drainage infrastructure, the things that are important to us. So use that permitting activity report to make sure that your contractor's doing the right thing. It's a link, and so we can provide the link, and we'll send it out as a follow-up to all the registration, everyone that registered today. Thank you.
And going back to that, so if a contractor does request you to pay a deposit, all of that permitting should be included in the deposit. You shouldn't have to pay for that separately because they have to do that to get started. Obviously, you don't want your project to come back later down the road and like, you got to tear this down. So you want to make sure that all the permitting and all of that has been completed before the contractor actually starts on what you've agreed to do. That's it. Did y'all have any questions for me? Yes, sir. That would be with your homeowners association. Normally it does. When we have contractors go pull permits, they have to get permitting from the city, the contractors, or the HOA, and they provide all that to the homeowner. But you would have to check with your HOA.
And as a courtesy, what we're trying to do to that very point, because there's so many developments happening in Houston, we have no zoning, right? We do responsible development. So what we've been talking about at council and really through the regulatory neighborhood affairs, that we need to send a notification out to homeowners, associations, and civic clubs to let them know this is what's happening, because we've had developments happen where they didn't meet the deed restrictions, they didn't follow certain, codes. So we're working on that. That is not an ordinance. It's more of a practice that we're trying to offer. And we're trying to get better at that. And so again, what's helpful is if you notice some development to let us know, then that'll allow us to get some more information. My colleague, Councilmember Sally Alcorn, just joined us. Thank you much. I would like you briefly, I know you're at the end of your presentation and he was talking about contractors and permitting, but could you speak to the Airbnb party house work that you're doing, and then also about permitting? Welcome to the West Side.
Thank you very much, everybody. Hi, great to be here. Sorry I was late. I had a funeral to attend. I did have a staff member here, and this is such important work, so thank you, Councilmember Thomas, for putting this on. Airbnb party houses has come to my attention throughout the city. So you've probably read a little bit about that in recent articles. We don't regulate Airbnbs in any way like other cities do. Other cities, like, they register them and they sometimes permit them. And so anyway, we don't do that in Houston. We do collect hotel occupancy tax money from them, but we don't have any really knowledge of where they are. It's been the attitude of the city to not really get into this business, but because there's been some bad actors and really some people that have taken over apartment complexes and made all of the apartments within a complex Airbnbs, that's been a big problem. That's a big focus. And then also just kind of other parties are banned by the company Airbnb, but people are still having parties, and there's not, there's bad behavior and criminal activity sometimes. And so there is a thought in the city. I know legal is looking at it. The mayor has signaled he wants to do probably something in this, whether it be on the apartment complex situation or somehow registering them. That's all being dealt with. We had a committee meeting on it this month, and so that I know the mayor and legal are all looking into it, and in the administration and regulatory affairs department. So you'll be seeing something coming out on that. I don't know how many of you have experienced issues with this in your own neighborhoods, but it's something we have our eye on. What Councilmember Peck, my vice chair, and I did was send a bunch of all the research we had on other cities to the mayor, and they're looking at that right now. So expect something to come out of that before he leaves his term. On permitting, it's been a big issue of mine since I first got into office, really just streamlining the permitting process at City Hall. We get all kinds of complaints of delays with city permitting. I know from a neighborhood standpoint, you want to make sure things are properly permitted. So you'd like the city to take its time to examine those permits. But if you have situations where you think there's work that's unpermitted, please let us know. We can check that out. The city sometimes has a kind of like, well, if it's been there a long time, if it didn't have a permit, we don't care, but we're trying to undo some of that. So I'm not sure specific what she wanted me to talk about permitting, but I'll answer any questions if you'd like about permitting. Yes, sir. Does not have to be. Does not have to be. That can be anonymous. We can just ask from our office, we want to check this out. So happy to do that. Yes, ma'am. Mm. Yeah, we happy to run any traps, as I know Councilmember Thomas is, on any specific issue. That should not be happening. I mean, if it's a residence, it needs to be a residential permit. If it's a commercial activity, it needs to be a commercial permit. So we can try to remedy some of that. But if you're seeing it over and over, that's maybe something systemic we need to look at.
And city legal did put a halt to that process at one point. But what's also happening in that neighborhood are squatters. And I'm sure that's happening throughout. We have squatters. And so again, that's a Texas, that's a state code that allows, there's a clock that starts. So if they inhabit that property for a period of time, they can absorb that home. Veronica back there has worked with us in Carver Crest to work on certain issues, but we have squatters all throughout. And so when people are deceased, and that's why the deed upon death is so important. So an identified family member can absorb that asset, because what people are doing, they know someone's passed away. They break into that home, stay into that home. They turn on the lights in their name. They pay the taxes in their name, and then the clock starts, and it allows them to do that. So you have to be sensitive to that, and that's happening in a lot of communities with individuals that are older. And particularly in Carver Crest, there's a landowner that has gone door to door to ask residents to allow him to pay their taxes and to sign their name to change the deed restrictions to allow him to have a larger number of vote, so he can put a commercial property in the middle of their residential. So those are the types of things that are happening. That permitting report is really, really important. I know it's just another thing to manage, but y'all are all HOA leaders and civic club leaders. That tool is incredibly important. And so if you have a contractor or someone that's doing work and you're suspicious of it, then we definitely can do that. And if you have a permitting question, and my colleague has led a lot of work around permitting to make sure that we're efficient and it's public facing, and that everyday Houstonians can digest that information. And so my office, her office, any city department will be able to facilitate that.
And one more quick thing, I don't want to co-opt just, but exciting news next week, you guys come into the Transportation Technology and Infrastructure Committee is the commercial and large vehicle changes. We're making it harder to park your trailers and your trucks and your commercial vehicles in neighborhoods. So the mayor, again, we send a whole bunch of things we want done, and he picks some, and we're getting those. Those are coming to committee next week, so I think on Thursday. So we're really excited about that. Thank y'all very much, and thanks for this good work. I mean, we are here to help you protect your neighborhoods in any way, shape, or form. So thanks for having me.
Yes, we have a copy. We have a copy of both presentations, and we'll make sure that is shared with Frostbank. Is that okay? We'll make sure that that's shared in the contact information for all the participants today. Sure.
And I do have some business cards over there, so my email address is on there. So if you do have any particular questions, you can always email me. Yes, ma'am. No, not yet. That's coming up next. She was interested in information about transferring the death deed, so that's about to come up next. Yes, ma'am. Good question. So she wants to know if the bank would allow the property owner to be their own contractor and select their own subs. So that depends on what type of loan product you're working with. If it's a home improvement loan, no, because we do require a licensed contractor to do it, and there's a mechanics lien waiver that's involved in that. But if it's like a home equity loan or a home equity line of credit, yes. So it all depends on the type of financing that you get at that point. Any other questions? Thank you for your time.
All right, wonderful. Now we have Ms. Diana and Ms. Selena with Avenue CDC. They're going to talk to us about the deed upon death and some other tools for home ownership. Thank you so much.
So my name is Diana Martinez. I'm the Director of Homeownership at Avenue. We are a nonprofit housing counseling agency, and our main focus is to prepare clients to become homeowners and to sustain their homeownership. I'm sorry about that. So today I'm here to present post-purchase homeowner education with the information on the transfer on death deed. Selena Alvarez is at my table, so if you want any further information or a pamphlet of all the services, feel free to stop by. So let's get started. So today's topics are the residence homestead exemption, the protest on the property taxes, and how to transfer your property upon death. So the residence homestead exemptions, how many of you here are familiar with it? From the tone that I've gotten, I'm sure you're really familiar with it. So it's very important that every homeowner applies for the homestead to be able to take advantage of not only the discount on your property taxes, but it helps put a cap on the value of your home so that your property values don't affect your property tax bills on an annual basis. So it's important to have that. So the benefit of the homestead exemption is to reduce the annual property tax bill by a percentage. On average, it's about 20% per property tax bill. So what the homestead does is every jurisdiction has a certain amount of what their homestead exemption value is, and that is reduced from your total value. So for example, for just purposes of numbers, if your home was worth $100,000 and the jurisdiction had a $20,000 discount, you would only be paying taxes on $80,000, not the full $100,000. And so that's a good way to help reduce with your property taxes. And it puts the homestead cap. So on an annual basis, the value of your home will have two values: the market value, which is what your home is worth in the market, and the appraised value, which it will be based off to pay your taxes. So it basically controls that your appraised value does not increase by more than 10%. So maybe a couple years it can increase by 2, by 5, but if the market is in good condition, most likely it's going to increase by the 10% cap. And so that way, after the second year, your property cannot increase by more than 10%. So if you want to see it that way, you're only paying taxes on an increased level of 10% per year at the most. There's different types of homestead exemptions. So if you're a general homeowner, you would apply for the general homestead exemption. But if you are disabled, you're able to qualify for the disability homestead, which has higher jurisdiction brackets. And if you become 65 years old or your spouse becomes 65 years old, you're able to get a larger discount on your property values. So it just depends on whenever you apply, what exemption you're applying for. And if you're a veteran or a disabled veteran, you'll get a further larger discount. So it's important to be able to know which exemption type you can qualify for and apply for that at the time.
Can I add one more point here?
Go ahead.
Harris County Tax Assessors also has an heirs exemption. So if there's a property, I'm one of 20 heirs of of 4 acres in Louisiana. We actually have an exemption for a property. So if you are an heir and you have siblings and there's a property that you need to maintain that was in the family, there's an exemption for that. And the reason why I raise the importance of that is because there were residents in Houston that were unable to qualify for Hurricane Harvey funding and repair because they didn't have the deed to the estate. They were living in their aunt's house or their mom's house for 20 or 30 years, and they didn't have any paperwork. And so, which means we are not allowed to repair your home during a disaster. So it's important to take advantage of all these tools. And when you're thinking about family planning, make sure you look at all of the exemptions that you qualify for. Because again, it's not a matter of if, but when we pass away, when there's another disaster, we want to make sure that our families have the tools to protect the assets we worked very hard to purchase and to maintain.
And it is important because if your family member were to pass away, the homestead is removed. And the moment that homestead is removed, that cap value is removed as well. So if your property member had been holding on to that cap, let's say 15, 20 plus years, the moment it becomes again into the market, then it goes back to whatever the current market value is. And yes, you can apply the homestead again if you make it your primary residence, but then you're starting at that cap at that new value. So whatever advantage maybe your family member already had, you would lose it in that time frame. So there's a variety of types. So it's just going to hcat.org or whatever county you're in, but it's the same exemptions for every county. And how to apply. So there's still the traditional method of doing the paper application, but now with everything, there's an app. So HCAD, Harris County Appraisal District, Central, they have a mobile app. So you basically just download the app on your phone, you fill out the app information of what your residence is, what's your name, you will upload a picture of your picture ID. It could be your driver's license or your state ID, but the document, your ID, has to state that your primary residence. So if you haven't changed your address, it's important to do that first before being able to apply for the homestead. And you only need to apply to it once. So as long as you continue to be the primary owner of the property, the homestead will renew on an annual basis. Around December or January, the county will send you a little postcard that lets you know, hi, Diana, you'll continue to have the blank homestead exemption for the 2023 or 2024 year. So you just want to make sure to find out and see what homestead exemption you currently have. If for any reason you don't receive the postcard, you easily can go online. It's public records. Go to hcat.org, type in your address or your name, search your property, and you'll be able to see on the left side what type of homestead your property has. So it's very important to still check it on an annual basis. At times, clients do refinance or get a home equity note, and that changes your title. So that can sometimes cause an issue where the homestead may be dropped. You want to make sure that it continues even after you do any changes to your deed. The requirements are submitting the application, doing your driver's license, proof of home ownership. You don't have to do that since they're connected to the county, but as long as your ID shows your name, they're able to obtain that information to determine that you are the owner of the property. And you must have lived in the property the first of the year. So if you happen to purchase the house this year, since we didn't live in the property January 1st, we cannot apply for the discount this year. But the moment you live in the property next year, January 1st, 2024, then after that, you can submit your application. There is a deadline to submit it by April 30th, but realistically, you can submit the application at any time. The only setback is if you do it at a later time, you may not see the reflection of the discount on your property tax bill, and you may have to get them to redo your bill so that the discount can be applied. But that would be the only setback. And again, the website is hcat.org. The other thing that's important is protesting property taxes. So the early deadline is coming up, so it's Sunday, April 30th is the last day to protest. If you did get your paperwork later than that, you always have 30 days from the date you received your letter to protest. So if you happen to have received your property tax value, let's say April 25th, you have until May 25th to protest. The oldest deadline is May 15th, and they still approve it based on that. So if for any reason you do not submit up till April 30th, you still have until May 15th to submit your protest. Everything, again, is electronic, so you can do the paper form, and the paper form is 50-132 form, or you can do it online, doing it through the iFile. And you basically create an account, submit the reasons of why you are protesting the value, any proof or documentation. It is best to have proof. That way they can be able to make that determination. And you'll have two types of visits. So there's an informal and a formal appointment that you will have with them upon a protest, unless you're doing the iFile. In the informal, you basically bring all your documentation, any pictures, any examples of why you're considering the value of your home to be less. If they accept your explanations, they're able to make the change at that time. If you are asking for larger amounts of protests on the values, then they may send you to the formal, where it's you representing yourself, an HCAD representative, and 3 impartial judges that will basically review both points to determine who has the right of reducing the value or keeping it at the current value. And so again, it's either mailing the protest form that we all get in the mail with our values, or going to hcat.org to print the form, or doing it electronically through your account. And it's easy by just searching HCAD. If you're in Harris County, typing your address, and then on the top, you'll be able to see where it says protest your values. So it's very simple to be able to do that. Any questions on property taxes before we continue? Go ahead. So how do you assess your market value? So one easy way is comparing your property to your neighbor's property, right? So if you're in a neighborhood where almost all the times there's homes similar to yours, so you can go to HCAD and basically see your square footage, your living square footage, and then your square footage of your land, and compare it to another property. As if that property does not have a homestead, it's a good way to get people to compare it to yours to determine it. So for example, if there's a 15 square hundred feet down the street, and there's my property, and that property, let's say, was recently renovated, and it was just sold for, let's say, $150,000, but yours is currently at $200,000. That's one way to be able to compare it. So you can go to par.com, print out the pictures of that property that recently sold, and then show pictures of your properties if it needed repairs or needs renovations to it. And that way, that would be one way of demonstrating it. If your property currently does not have up-to-date maintenance, right, there may be repairs that is needed, you can take pictures, try to get some quotes on what the repair costs would be, letting them know this is what the damages are. During Hurricane Harvey, during Ike, a lot of properties were damaged, and they were able to protest the values while the repairs were being done. So that way the value could be decreased, pay less in taxes, and then eventually when the repairs were done, the value would go back to the property. But as many properties did not get repaired, then their value stayed at a lesser level. Yes? So whenever you're looking at properties, you're able to see the sales price. When you go back to the property, there's a range of what the homes were sold for. And so in that same sense, you can look at the range. The range is always going to be between what the property was actually sold for. HCAD only has the market value and the appraised value. So you would have to do extra research, like going to har.com, seeing what properties in which you could do it yourself. Mm-hmm. Correct. So every jurisdiction has different exemption values. So some may have higher values than others. Some MUDs may only have like a $5,000 or $10,000 exemption value. So yes, across the board, there's different values that will be reduced depending on what jurisdiction your property is located at. So last year in May, they did approve a larger discount on elderly. And so if you look in your values, you're able to see what that value is. Like I said, again, it all depends on the location of your property. But if you go to hcad.org, you type in your address, in that center portion of the website, it will have the homestead exemption, the list of your jurisdictions, and then the exemption values. So you'll be able to see exactly what the current values are for that. And so let's say if the value is $100,000, the current home value, and the exemption is $40,000, then you know it's 60. When it's over 65, the amounts are a lot larger. So it's not necessarily that it's in the city, it can be in the outer areas. So for example, and a lot of people think that because your address may say Houston, that you're in the city area, and not necessarily. So for example, my address is a Houston area, but I'm outside Beltway 8, and I don't pay city taxes, but I do have MUD taxes. So a lot of clients, because they associate Houston as part of the city, automatically think you're in the city area, but it's not the case.
And we only have one MUD in our district. So the city model is we're moving away from MUD. So the ones that exist were grandfathered in. So you should not have that. And I think it's Shadow Lake is our only MUD. Shadow Lake should be our only MUD district that we have.
Mm-hmm. Yeah, when the moment he turns the 65, you can no. The moment he turns 65, you can apply for it. That's to protest. That's the early deadline to protest the values, but you technically they're still grandfathering in the May 15th traditional deadline.
But as far as getting the extra over 65.
Oh, the exemption, there's no deadline for that.
Okay.
So the typical deadline that they try to use is April 30th, but you can apply for the homestead at any time.
Okay, great. No
if for
fight.
any
No fight will
reason-
be had.
And if for any reason you, let's say, purchased a property, you moved in, and you noticed 2 years later that you didn't apply for the homestead, you are able to request them to backtrack at least 1 year. As long as you ask for it, you have to put it in the application.
So what impact can protesting your property taxes have on like a future potential sale of your home?
It has no impact. So the county does not have the capability of going to every property on an annual basis to determine the true value of your home. So they're basically looking in the community what has changed, what has improved, that could have caused an increase in value in that area. So if you are protesting your values, and let's say you brought it down by a couple 30,000 or whatever amount it is, upon sale, it doesn't affect that. So you can basically just put it on the market. You'll hire a realtor that will give you comps or ideas of what your property can be sold in the neighborhood that you're at. And then you make the determination of what you're selling it for. And so the only thing that would be something that could reconsider that amount would be the buyer doing an appraisal on the property and that appraisal coming back at a lesser value. Then that's when you would have to renegotiate to see if you're willing to bring it back down. But if the appraisal comes through, then there's no worry about that. So there's no connection between what the county says your property is worth and what you can sell it for in the future. Any other questions?
And I've owned it for like 30 years. Then I get married. And so I'm 65, but I die, but the husband is not on the deed.
So in that case, unless that member is part of on your deed, with the over 65 doesn't go based off, it's not like grandfathered in. So whatever the owner is at the time will get that discount that they apply for at the time. If they're as well 65, then it would be that. So for example, I had a client where it was the daughter with their parent, and their parent was 65, so they would get 50% of the over 65 exemption. But the moment her father passes away, then it's just going to go back to just her 100% general homestead exemption.
And pay the full.
Pay
Or
whatever.
reapply.
Yeah, the newer exemption, the general one, not the over 65. So the over 65 does not follow or stay on the property once that person passes away. So, but if that other person is the equal, receives the same exemption, then yes, they would continue to have that over 65 exemption.
Well, if he
on the
was
property.
already 65, it would just.
Correct, yes. If it's the same age bracket, yes. Any other questions? No? Okay. So the main topic that many of you may be interested more on is on the transfer on death deed. So unless we leave a will to let your family know what property is going to belong to who, then most of the times our clients will not have a will, and that's when issues come down the road. So sometimes your grandmother left a property and then it went to a grandson or a nephew or whatever it may be, and title is never transferred because everything is good. You just pay taxes, you pay insurance, there's no problems, no issues, especially if there's no mortgage. But if a disaster comes through and you want to apply for any type of assistance or help from FEMA, you have to demonstrate that the property belongs to you to be able to receive any of that funding. And most of the times the clients don't have that. They never made sure to transfer the property. And then the setback is you have to go through the legal route of doing that before applying for any type of assistance or help from any type of organization or agency. So the transfer on death deed is a new right that we have in Texas where you can transfer the property to a potential heir upon your death. So until you pass away, that member can take ownership of the property. And so we get our information from texaslawhelp.org. It's another nonprofit agency. They have a really good tool. It's called the Texas Transfer Toolkit that has all the information of what the process is. So what this is transferring the property to someone, whoever you want. It doesn't have to be a relative. It's inexpensive. It avoids the issue of going through probate court. And it's similar to like a life insurance policy or your bank accounts that are payable on death. So in a bank account, you can put payable on death to this particular person. So all they do is demonstrate with your death certificate that you've passed away, and they have rights to all the funding that's in that bank account. Similar with the transfer on death deed. So you would basically record your information in your county, letting them know who your heir is going to be or the new owner of the property upon your death. and that is basically recorded with your note or your deed, depending on what you may have. And then upon your death, then it's transferred to this new heir. And so you continue to be the owner of the property. So just because, let's say, you put a family member, let's say your child, as the potential owner, they have no rights to the property. They cannot go and try to get a lien on the property, get a loan, try to sell the property, because you continue to be the owner. The only thing is you're just stipulating, if I pass away, this person becomes the owner. So the beneficiary has no legal right until your death. They do become responsible if the property has any mortgage or any debt on the property. Just because you pass away doesn't mean that that debt is basically erased. So yes, they're the owners, but they have to continue payment on whatever liens or debt that the property may have. And it only transfers your part of the ownership. So if you are in ownership with someone else and it's 50-50, and I transfer my 50%, they're only owners of my 50%, not the entire home or dwelling. It can be canceled at any time. So let's say you pick your favorite child today, and 5 years from now, you don't want that child to be the homeowner, then you could just go remove that or update the transfer and death deed and basically transfer it to someone else. You have a question?
Yes, you mentioned something about recorded with the county.
Yes.
Can you specify what?
I will,
where, and
in
how?
our next slide, I will basically explain the steps of actually doing this. You need this?
If we have a will, basically, if we have a will with that specification, do we still need a transfer of death deed or no?
So in that specific scenario, you would want to speak to your lawyer to
Okay.
basically see which one's the best option for you, either going through what you already have stipulated or doing a transfer on death deed without the need of the probate court. So it's just depending on whatever assets that you have, depending on on the client.
So if you didn't want to go through the lawyer, you could do a transfer of death deed and have both.
So many of our families in our nonprofit don't have that many assets. Technically, the home is their only asset. So doing the transfer on death deed is more economical to them because all they're doing is paying the recording fees. They don't have to pay a lawyer or do any type of paperwork to basically have a will or to leave a trust or anything like that. So it just depends on the household to see which one's more beneficial for them.
Okay, thank you.
Yes, ma'am?
Two quickie questions. On the transfer on death deed, does this keep it out of the valuation on your estate for estate taxing purposes? That's question number one. Number two, must I transfer it to a human being, or could I, for instance, transfer it to my university?
That's a new one. I've never heard about that. We could probably ask. I could definitely take your information and I could share it with Tiffany on that response, and I can ask that to see if you can donate it to an organization or any company in particular. But yeah, that one is a new one. I haven't seen that. And on the first one, yes, this has nothing to do with your tax valuation. But oh no, on that question, you would have to definitely ask a lawyer on that. You would have to let them know that you're doing a transfer on death deed, and then they would make that determination. It depends on your county and what the pages are. So the question was, what is the cost to do the recording? So it's basically whatever the county where your property is at on what they charge. And it's typically, I think it's $16 for the first page, and then any additional page maybe between $6 to $8. So it's not very costly. Yes, sir?
If you have a property out of state, do you have to have paperwork from that state, or would this qualify?
So on that scenario, you would have to go with the state and see if they have this law available in your state. So in Texas, we have the ability of doing the transfer on death deed. So in the state where your property is at, you would have to see if that is something that they do in that state.
And there are about 20 states that participate in deed upon death.
You can put as many people as you want, and you would put a percentage of what of each one would be of ownership. And you can change it as many times as you want as well. Yes, sir?
I'm sorry, years ago, but I'm very old. Is there some way to check online to see if that's the case?
Online, you could go to the Harris County Clerk's office and basically do a record search on your name. If you are savvy enough to look for your name, you could basically put in your name information and put the time frame. So if you put the time frame of when you remember, let's say 2010 to 2020, it'll pull the records about your name. And so you should see your deed, and then you'll be able to see the transfer on death deed. But if you're not able to find it, the easiest way would be just going to the county clerk's office to find out what's registered under your property, and they'll let you know if it's registered or not.
Thank you very much.
And if you don't change it, it continues to be on there. So it can be canceled at any time, like I said, and always talk to a lawyer just to see which was more beneficial for you, either doing a traditional will or a trust, or just the easy route, depending on how many assets you have, doing the transfer on death deed. And so the process, so there's a two-step process. So as the owner, you have to fill out the transfer on death deed form, and that form is basically filled out with any notary that can help you. Basically, you're just filling out the information, notarizing it, and then taking that document and recording it at your county clerk's office. So it's wherever your property is at. You don't want to go to Montgomery County if your property is in Harris County. So you want to make sure it's registered at the same location, and you'll be paying the recording fees, very minimal of what they cost. Upon your death, your beneficiary needs to know or be aware of that. So you do need to let them know beforehand that you have stipulated this transfer on death deed, so that they are aware that upon your death, they need to go to the county and demonstrate their ownership. And what they'll do is they'll fill out another form called the affidavit of death form, provide proof of your death, which would be your death certificate, and sign it as well in front of a notary, and then take those documents to the county clerk's office, the same one, and record it. And so when the county clerk's office sees your previous forms and then the new forms, then they're able to automatically transfer the property to the new heirs, and with no issues at all. So no need to go to probate court to do all the transfer papers, so it's automatic. Okay? And again, the website where you can get this cool toolkit is the Texas Law help.org, and you just type in Texas Transfer Toolkit, and it's a packet about 28 pages with very detailed information with both forms basically ready to go for you to just to fill out, get it notarized, and go to your county clerk's office to submit.
I believe there's also one of these for a vehicle. Is that correct?
On the vehicles, I'm not familiar with.
Else?
That I'm not familiar
Some people nodding.
I know you can gift your vehicles, but I don't know if upon your death. Any other questions? And so just to briefly let you know of all the services that we do, so we are with Avenue. We are part of the homeownership department. And so our main thing is educating and preparing clients to become homeowners, and for the homeowners that we do have to sustain their homeownership. So we provide homebuyers education classes. That is a requirement for any down payment assistance programs that we have in the area. And we do have a variety of programs. We're a lucky city that has a variety of programs that can help our clients become homeowners. The certificate is also a requirement for certain lenders to either get a discount on your interest rates or any type of lender credits or lender grants that they may have as well. And we also offer pre-purchase counseling. So if a client is not familiar, if they're ready to purchase a home, we're able to provide counseling at no cost to them and review their finances before they get a hard hit with their mortgage lender. So we're able to see, are you mortgage ready? Are there any things that you need to work on to be able to become mortgage ready? And with the industry that we're in right now, it's very difficult for certain clients to become homeowners. So it's important that they get the education and the counseling beforehand so that they are aware of where they're at and then be ready when opportunity comes. Sometimes clients may say, because of the media, this is not my time right now. I'll just do it maybe a year or two from now. And then an opportunity comes up. They want to do it, but then they find out their credit's not sufficient, their debt's too high. So it's the time right now is to get educated and prepare your finances so that if something does come up, then you're able to easily just jump on board and apply for that mortgage loan instead of finding out that there's a further delay. And we do post-purchase education and counseling. So we do property tax workshops. So we will be having the Harris County Tax Assessor on May 10th and May 11th. It's a virtual Zoom webinar where you can ask any questions about your property tax bill. So they will exactly talk about the exemptions, talk about how to make your payments if you're trying to do a payment plan or a deferment. So you can defer your property tax bills and you won't have to be responsible for them. And whenever the new heirs take over your property, they would be the ones responsible for paying your property tax account. And if you're interested in either refinancing or applying for the homestead and you need assistance, we're happy to help you with that as well. We can do a counseling session, submit the application for you, and help you in that process. And if for any reason, if you have a client or know someone that falls behind on their mortgage loan and becomes delinquent, I know through COVID, a lot of families were affected because they took advantage of a forbearance, basically delaying their mortgage payments without knowing that at the end of this forbearance, they were still expecting full payment. So we have a counselor available that can help a client basically determine what options they have available with their mortgage lender to prevent them from losing their property. We are fortunate that Texas has homeowner assistance funds. So if a client was affected by COVID, the counselor can submit your application to try to get funding to bring you current with your mortgage. And so it's not necessarily your mortgage, it can be your property taxes, it can be your HOA, it can be utilities, and we can submit an application to bring you current with these items. So all our services are free. The only thing we have a fee for is our class, which is $50. But other than that, all the services are free. So if you need any information, feel free to stop by our little table, get a brochure from us, and sign up if you're interested in receiving any information from us.
Thank
Any
you
other
much. Let's give a
questions?
round of applause for our speakers today. Thank you so much. In an effort to return the rest of your wonderful Saturday to you, I want to make sure we have a brief closing remarks and just some housekeeping reminders. You do have resources on your table. Please take an extra folder and bring it to your neighbor, some of your HOA colleagues that were not here today so they can have these resources. Please get with Centerpoint, Frost Bank, and Avenue for those resources, because even if it may not be applicable to us, we know someone that this information might be critical to. In response to today, all of the program participants will receive the presentation, the permitting link so you can verify that, and additional contact information of our partners today. I want to thank you for deciding that this was a priority for you and coming today and getting your questions answered. This will be the first of many as we work to protect our neighborhoods and improve the quality of life. No matter if you're in District F or Fort Bend County or whatever, it's all very, very important. So I want to thank you for that. Again, we have some register your civic club or your HOA so we can have that in the city's master database. That's really important as we work with City Legal. If you think you did it and you don't know, just go ahead and do it again. We want to make sure that the planning department has that. And I want to remind everyone about the Livable Places initiative that's coming up for the agenda, so we can get your feedback on that that additional home on property, particularly in Carvercrest and other neighborhoods. But it's critically important to have your feedback on that Livable Places. And my colleagues nodding her head because that's a critical thing, and we're already swarmed in our emails about people are kind of frustrated with that. So any questions for me? If not, we will definitely be in touch. Enjoy the rest of the weather. I would offer you some food, but that is gone. Thank y'all so much. This is recorded with HTV. This will be showing on channel 16 once it's done, and we'll send this out in the newsletter. It'll be on the District F website, and it'll also be one of the artifacts that we attach in a follow-up. Thank you so much.